filed seeking leave to file my inquiry report, Your Lordship. The urgency is that on 31st October, the petitioner is retired.
I cannot entertain now. You please give the slip. It will be taken up after the vacation.
Oh, this matter, my lord, has already disposed of on 27th September, my lord, 2023. My lord, in this matter, my lord, our name, I appear on behalf of state, my lord.
Your name has not appeared.
My lord.
It will appear as to be mentioned. All right. It will appear as to be mentioned, and then I'll correct it.
I permit to mention, Lordship, one matter, Lordship. Lordship, 2019, Lordship, the joining letter was issued by the concerned department, appointment letter, but till date, no joining letter has been issued in favor of the petitioner, Lordship.
Is it in the motion stage?
No, Lordship, it has been released by Honorable Justice Vishwajit Basu because the matter was filed wrongly before his Lordship.
Is it in the motion stage?
Motion stage, new motion, Lordship.
All right. You
I
have given notice to the other side?
Yes, Lordship, Ms. Jhuma Chakraborty is appearing for the state. I have, Lordship, informing by notice, Lordship. I will place the notice.
Lord, may we permitted to mention on restoration application.
Great.
All right.
My lord, restoration application, my lord,
All right.
restoration application, my lord.
Please give the slip. It will appear on Friday. Yes.
Table motion. Returnable motion.
Returnable motion you want to mention? It has not appeared in the list. Returnable motions, I always give the date on which it is supposed to appear. It has not appeared, madam?
Yes, ma'am.
It has appeared. Then why are you mentioning?
My lord, kindly.
No, you have to tell me. Why are you mentioning? So it is not returnable motion. Why are you making such submission before the court? Is it a returnable motion? There is directions for affidavit. Is it a returnable motion? Do you have an instructing advocate or are you the advocate on record?
My senior is advocate on.
Your senior can't be the advocate. Your senior is the advocate on record and you are not the advocate on record. You talk to your senior and come back. Yes.
That's your one restoration application.
All
It was.
My lord,
One-
may I?
Yes. Yes.
Under compelling circumstances, Your Lordship, I'm mentioning Your Lordship. Before I mention Your Lordship, I beg your pardon, Your Lordship, for mentioning Your Lordship. Your Lordship, under the heading, Your Lordship, for orders, Your Lordship, there are 10 matters. Out of those, Your Lordship, this 4 matters are recovery matters, which I'm covered by my Lord's order. If my Lord, it's my earnest request, if my Lords kindly take up the 4 orders.
I will see, madam. If it is possible, I will.
Lordship, I'm grateful.
My lord, may I be permitted to mention on a returnable motion, which is listed today as 111 is the item number. My lord, with the prayer for upgradation of this returnable motion.
Sorry.
My lord, the reason behind that is the 27th October is the last day of selection for the candidate appearing for the post of constable in the BSF, and the candidate is actually rejected in the medicinal ground only by because of the having hemoglobin at the range of 11.7.
No, please wait.
but-
It will be called on. It will be
May I
called
My
on.
lord,
Yes.
notice also has been served to the.
Yes,
my
but
lord.
I cannot upgrade it. Yes.
May I permitted to mention, my lord, new motion matter, my lord, read petition, my lord, in this court, my lord, listed, but can one, my lord, listed in wrongly, can one, my lord, laying in code number 17, my lord, wrongly, my lord, filing, my lord, can one addition of party, my lord, can one?
So you pray for release from that court. Why are you coming here? You pray for release and then you come.
My lord,
If it is appearing before some other court, how can I take it? Take it up.
read petition pending, my lord, this court.
হ্যাঁ কিন্তু ক্যানটা ওখানে ফাইল করেছে ওখানে রিলিজ করিয়ে আসুক তারপরে আই উইল ইনক্লুড ইট ইন
Requisition is
ওরা তো ক্যানটা ওখানে ফাইল করেছে
ওই কোর্টে চলে গেছে।
না না ফাইলটা কি এই কোর্টে করা হয়েছে?
কিন্তু এটা অরিজিনাল সার্টিফিকেট এরকম হয় না ওদের না রিলিজ করলে
ওখান থেকে রিলিজ করাতে হবে।
তুমি দেখো কারণ
ক্ষমতা নেই।
ইনি ডিরেকশন দিলেই রিকুইজিশন ওরা বলছে রিকুইজিশন যদি এই
ওরা
কোর্ট থেকে যায়
ওখানে ফাইল করেছে ওখানে না ওদের ওখানে মেনশন না করে চলে আসবে এখানে
এখানে প্ল্যান তো মেইন লিস্ট
all right we'll see come back next week we'll see what can be done you please give the slip we will inquire in the department All right.
Lord, may I permit to mention for extension of interim order, it will expire on 13th.
It will appear as to be mentioned. Please give the slip. এই চলছে না Mike?
Mr. Shudhashattu Banerjee was appearing in this matter, Your Lordship. 3 matters were heard together, Your Lordship. The first matter, HON'BLE Chandra Deka, it was there needs to be no correction, Your Lordship. He was given appointment on a contractual basis. But the second and third matter, Your Lordship, they were given appointment first. Then their appointment was confirmed, Your Lordship. Therefore, there was no contractual appointment, Your Lordship. So the word contractual in the third line of the order needs to be corrected, Your Lordship. The word needs to be
Instead of
deleted.
engaged contractually, I will just record appointed.
Yes, yes,
And
Your
the
Lordship.
date?
Appointment date is correct, Your Lordship.
Date of
I had
appointment is
given on the last date the dates for appointment. So instead of the word contractually, appointment.
আচ্ছা এটা তো ঠিক আছে এটা কিছু অর্ডার হবে না সেকেন্ডটা রাখো
Your Lordship, the first one need not be
I
corrected. The
have
second and
understood
third.
এটা কিছু কারেকশন হবে না আসুন by an order dated August 22, 2023, this court permitted the parties to mention the matter for hearing bolded upon completion of the period stipulated for exchange of affidavits. Full stop. On the third line at page 1 of the order, the petitioner was described to be inverted commas and mudda italics say engaged contractually, inverted commas closed. Full stop. However, comma, the petitioner was appointed, inverted commas italics, inverted commas closed, on inverted commas italics, appointed for a inverted commas closed on February 13, 2012, full stop. Let the order appointed, italics, be substituted in place instead of engaged contractually, italics.
Faithful, Your Lordship.
Inverted commas kore deben. Let such inadvertent mistake be corrected, full stop. Next. Let this order be incorporated in the order dated August 22, 2023, full stop.
Grateful, Your Lordship.
Just wait, wait for item 3.
2 and 3 both.
Yes, just wait. Let me get the file of item 3.
I am appearing only item number.
All right. আসুন একবার সবকিছু ঠিক হবে এখানে July 28, 2009 হয়ে যাবে date of appointment. ঠিক আছে?
On behalf of the petitioner. But this is revised, my lord, national.
Please give me your affidavit of service.
My lord, on the last day, my lord, I have.
All right.
Mr. Tapon Mukherjee, my lord, appeared, my lord, on behalf of the state. But kindly see my lord's last order. Here, my lord, the contractual appointment, my lord, the age limit was given up to 65. Now it has been, my lord, by 2 circular has come down to 60. That is the, my lord, impugned before your lordship. Your lordship asked for a report, my lord.
I'd asked for some instructions.
Yes, yes.
Now, what is your age now?
Lord,
age of
some
the
of the
petitioners?
petitioner, my lord, are going to superannuate, my lord, due to, my lord, this their age. That's why, my lord, the,
When?
my lord, two of them has already retired and
November 29. Two have retired in July.
yes,
November 29. Two more will retire.
yes. Page 12, my lord, your lordship. Page 12. My lord, the circular, my lord, the initial circular, your lordship will get, my lord.
I will keep it at, try at 1 o'clock.
Very
If not, then I have to post it after vacation. How?
Very well. I shall inform him if he can come.
Inform him, maybe he's engaged in some other court.
Very well. I shall,
Junior should have been here.
but I shall inform.
Let me try.
Grateful. একটা সময় পরে।
But 5 minutes, I am for the.
I am for the petitioner, my lord. My lord, they stated in the report that no work, no pay. So, my lord, medical leave, my lord, they are not allowed to let them consider that representation, my lord. What can I do?
You were supposed to also bring on record your engagement letter.
No, there is no such. I have
This is the
heard
thing. Then
that.
you
So
also
what
support-
I am paying for because of pregnancy, my lord, she was
yes,
absent.
but she is a daily rated worker. Her
No, no.
case is that
Let
she
let
was-
them consider that representation.
all right.
That I can say.
She did not make any prescription before the.
Yeah, you consider and reject.
My lord, that
It will be good for him also. Otherwise, if I outright reject it, it will not be good for him also, no?
my lord, annexure P2, page 9.
I am looking at P2. But this is application for leave. This is not your representation. Then where is your representation? You don't even have a representation.
No representation is there.
This is application for leave. Now what will you do? This was in 2021.
My lord, let them file and consider that.
Ashun,
কি করবো যা আছে তো জোরে কিছু বলতে পারবো তাই
the petitioner's case is that she was working as a receptionist with the State Fisheries Development Corporation Limited within bracket SFDCL bracket close full stop. By a letter dated October 5, 2022, the petitioner prayed for 2 months leave with effect from October 1, 2021. Letter dated September 25, 2022. 2022. The petitioner's grievance is that she was not allowed to rejoin her duty after a period of 2 months. Full stop. Mr. Haldar, next. Learned counsel appearing on behalf of the petitioner submits that the petitioner's prayer for leave should have been considered and the petitioner should have been allowed to rejoin her duty. Full stop. Next. Ms. Das, learned counsel appearing on behalf of SFDCL filed her written instructions on the previous occasion. Full stop. She submits that the petitioner has been absenting herself from work from September 25, 2022, full stop. There was no formal letter of appointment stroke engagement issued in favor of the petitioner, full stop. The petitioner is a daily rated worker, full stop. There is no further requirement to engage her at the project of SFDCL at Oceana Tourist Complex, full stop. Next. Considering the rival submissions of the parties and the materials placed on record, this court is of the view that justice will be subserved by directing the respondent authorities to consider the representation of the petitioner within 6 weeks from the date of her making of a comprehensive representation before the respondent numbers 2 stroke project in charge, full stop. Next. A reasoned order shall be passed and communicated to the petitioner within 2 weeks of passing thereof, full stop. Next. With the directions aforesaid, WPA 16678 of 2023, bolded, is disposed of, bolded, full stop, server copy. Server copy, certified copy.
My lord, I am for the petitioner. This is the affidavit of service.
Lordship, I beg to appear on behalf of the respondents.
Yes.
Petitioner has applied against a notification dated 21st July 2018. Notification was circulated from the Staff Selection Commission for the post of Constable GD CAPFs, NIA and SSF Assam Rifles.
All right.
Okay. Page number 15. It has been noted that e-admit card was issued.
Yes.
Later on, kindly see page number 16. Later on, the petitioner has succeeded in the computer-based examination.
All right.
And physical efficiency test, that is PET or PST, on 23rd March 2019. 16 to page number 16 to 18.
Yes, he has qualified.
Okay. He then appeared for the detailed medical examination, that is abbreviated in the DME. Page number 19. Appeared in the DME examination. And according to
Page
the
number
19. 19. 19.
19.
Detailed medical examination.
This is the e-card for DME.
Yes.
Where is the report of the DME?
No, it has been reflected later on,
Yes.
on the result.
Yes, show me the result of the DME. All right, you place in your own manner.
My lord. Page number 65. My lord, kindly see page number 65 relating to the publication of the result in respect to the DME later on.
Yes.
Page number 65. Page number 65. The name of the petitioner has been circulated, tabulated here, Gulshan Kumar Kanojia, and the record 22026. Page number 65.
Yes,
Record number 22026.
yes.
And the heading Constable GD in CAPFs, NIF, such and such, list 2 male candidates recommended for appointment in roll number order.
Yes.
So after the completion of DME, the petitioner has been tabulated here as a qualified candidate. Later on, page now, kindly see page number 74.
Yes.
Several pages are there, but I have only annexed the one page from that, which has been circulated from the website.
Gulshan Kumar Kanojia.
Kanojia.
All right.
There, it is clear that final allotted unit in RRC has been published by the Staff Selection Commission, where the petitioner's name has been entered under the registered ID 740010213889. An allotted unit is there, 21st Battalion.
Yes, then what happened?
Still now, the petitioner has not yet
Received his
in-
appointment letter.
Yes. Regarding one issue, they have stated after communication, it has been stated by the
What is
department.
your, yes, Right to Information Act, what information have they given?
Yes. My lord, page 81. However, it is informed that your client roll number such and such, Gulshan Kumar Kanojia, has been provisionally selected as against the vacancy SC category, whereas he produced caste certificate issued by the UP government and domicile certificate issued by the SDM Bardhaman Sodor North. His mismatch matter has been sent to SSC to revise the result on the basis of his actual data. My lord, kindly see page number 82. Last half of the communication, that Gulshan Kumar Kanojia, roll number such and such, received in the commissions through nodal CAPFs due to mismatched data of caste certificate submitted by the candidate, and the matter is under examination in the commission. That is dated 12/5/2022. And after that, the petitioner has
Show me your domicile certificate. Who has issued your domicile certificate?
Yeah.
Show me the domicile certificate.
page number 70. 70 and 71.
Yes.
My lord, may kindly take page 22 once more. The eligibility criteria for this job, my lord, 3. Must be citizen of India. Vacancies are state, union, territory wise. Hence, a
Page
candidate.
22.
Huh?
22,
my lord.
Yes.
22. 22, 3.
Yes.
Nationality, citizenship. Candidate must be a citizen of India. Vacancies are state, union, territory wise. Hence, a candidate must submit domicile PRC against his or state duty, my lord. No, my lord, this candidate admittedly has produced domicile certificate of West Bengal and caste certificate from my lord UP. So this vacancies were particularly against the state vacancies, my lord.
Yes, he has produced domicile certificate of the
Get
state.
from domicile certificate from West Bengal and as caste certificate from,
There is no requirement that the caste
my lord,
certificate has
now
to be
on that ground it has been,
produced by the state.
and my lord,
Domicile certificate of the state has been produced. Then
my lord, 81, my lord, 82, my lord. What they have said, my lord, it is under consideration. Let us take instruction on this. What has happened to
1 year passed.
how long will you take?
my lord? Give us
Uh,
2 weeks time. We will take instruction.
It's pending for such a long time. How long will you
My
finally
lord, 2
take
weeks
to
time. 2 weeks time, my lord, may kindly be accommodated.
resolve this issue?
2 weeks time may be kindly be accommodated, my lord. We will take instruction, my lord. What happened to this, my lord?
And you have not made the SDO a party. I'm giving you leave. You add the SDO a party. The
Okay.
person who has issued
Obliged.
the domicile certificate. The only thing they are required to see is that whether you're a domicile or not of
Okay.
the state. You make the subdivisional officer a party.
Okay.
Ashu. Leave aspirate for to make the subdivisional officer, comma, Burdwan Sadar, within bracket north, bracket closed, comma, Purbo Bardhaman, a party to the present writ petition is granted. Leave is given to make necessary changes to the cost title. Full stop. Next. It is the case of the petitioner that despite being selected as a constable within bracket GD in the 2018 examination held by the Staff Selection Commission within bracket SSC, bracket closed, for recruitment to the post of constables within bracket GD, bracket closed, in CAPF Choto S, comma, NIA and SSF and rifleman within bracket GD, bracket closed, in Assam Rifles examination, comma, the petitioner has not been given a letter of appointment till date. Full stop. Pursuant to an application filed by the petitioner on February 17, 2022, under the Right to Information Act, 2005, it has transpired that the authorities concerned are trying to solve the issue regarding the mismatch that appears in his caste certificate vis-a-vis caste take korun italics, his domicile certificate, domicile take italics, full stop. Caste certificate vis-a-vis his domicile certificate. ওই দুটোকে just word গুলোকে italics এ করে দিন, full stop. The caste certificate has been issued from the state of Uttar Pradesh, whereas the domicile certificate has been issued from the state of West Bengal. Full stop. Next. The matter is pending before SSC since 2021. Full stop. Next. By a communication dated May 12, 2022, the Undersecretary and CPIO, SSC, Department of Personnel and Training, Government of India, indicated the petitioner's advocate that The matter is under scrutiny stroke examination by SSC. Full stop. Next. Learned counsel appearing on behalf of Union of India is permitted to take necessary instructions in the matter. Full stop. Such written instructions will be brought on record on the adjourned date of hearing. Full stop. Let the matter come up for further consideration under the same heading motion bolded on December 4, 2023. Bold.
My lord, December 4th.
Serve a copy.
Grateful, my lord. My lord, notice may be issued to the STO, my lord. So, if they,
a service will be effected on the added respondent and a proof of service be filed on the adjourned date of hearing.
grateful, my lord.
It is second paragraph to have. This is
With the leave.
May it please your lordship here. This is one that matter, my lord. This is supposed to go to courtroom number 17, my lord.
The primary matter, my lord.
And my lord, one more thing, my lord. Second paragraph of your lordship's order of 3rd of October had created some problem because, my lord, probably this got the third paragraph of your lordship's order of 3rd October. That created some problem for my advocate on record to serve it on the state. Because nobody was representing, my lord. So that may be deleted.
nobody was representing, then why have I directed this?
No, my lord.
Maybe after you have left or something has happened.
No, my lord.
Then
Nobody,
why, how
because my lord, the state was not served. Your lordship had directed me to serve the state. If your lordship sees,
where from I have recorded it?
probably from some other order, my lord, got
You cannot be.
very well. A leave may be granted to correct the presentation form and my lord.
Ashu. এইটা না একটুখানি আপনারই করা এই দিনের লাইভ স্ট্রিমিংটা একটু দেখবেন যে এই প্যারাগ্রাফটা আপনি কোথা থেকে করেছেন, তাহলে দরকার হলে এটাকে টু বি মেনশনড দেবো, এটাকে লাইভ স্ট্রিমিংটা দেখবেন। আমি এটা কোথা থেকে অ্যাড করলাম, কারণ উনি বলছেন মিস্টার সেন নাকি অ্যাপিয়ারই করেননি। অনেক সময় হয় ওরা বেরিয়ে যাচ্ছে তখন এসে ওরকম ভাবে।
If that was the case, my lord, I am not aware of.
Did you watch the live streaming?
No, my lord, I have not.
Then I have to watch it and find.
No, I'll check it myself, my lord. I'll check.
You will also check it. I will also check it. Ashu, লিখুন this writ petition has been filed wrongly under group 6, Roman 6, full stop. Accordingly, let it be released, bolded from the list. Next. Parties are given leave to correct the presentation form and take necessary steps for filing of the writ petition
No.
before the appropriate court, comma, if so advised. For the filing, listing the writ petition before the appropriate court, comma, if so advised. Full stop. Server copy.
Much appreciated.
এটা একবার দেখে নেবেন তো আপনি,
I
নাহলে
shall.
আপনি মানে পেলাম কোথা থেকে।
I shall also.
8. I am for the respondent, my lord. My lord, I am for the petitioners. My lord, undisputed fact is this, that the petitioner served total 36 years service with the respondent from the year 1979 to 2015.
Right.
My lord, undisputed
2013.
2000 from 1979
Yes.
to 31st August 2015.
15. I have recorded 13 in my order, previous order. From where did I get? All right. Then what happened?
My lord, dispute. He has been paid gratuity only for the period from 1998 when the petitioner was regularized. Before that, a substantial period, that is from 1979 to 31st August 2015, he was temporary. For
Tell me
this
the
period, he has not been paid.
Tell me the period for when he was temporary.
My lord, 79
79 to
1998.
1998.
From 1/8/1998, his service was regularized. Before that, he served a substantial period as temporary workman. For that period, he has not been paid gratuity. My lord, for the purpose of entitlement of gratuity, as per Gratuity Act, entire service period from the date of joining, it will be counted. That is,
Was it a continuous service?
My lord.
Was it a continuous service?
My lord,
Continuous
Under
service.
2A.
My lord, it is continuous service. I have given the particulars. No, I have given the full particulars. My lord, at page number. Page number. My lord, at page number 5. Page number 5 of my petition, I have given.
One second. Yes.
my lord,
Yes, you have the instructions.
I have the instructions. My lord, from 79 to 81, the petitioner from time to time has been engaged as casual employer, casual worker, or a work charge employee. In 1998, he was regularized, and his service certificate, which has been issued from time to time, clearly states that reason for termination in every certificate, that is retrenched, and retrenchment benefit has been paid to him on every occasion from for a period where he was employed as work charge employee. Now in the year 1998, he has been regularized.
The question is whether he has been rendering continuous
There has
service.
been
You
from
file a
time-
report
I will file-
showing every year from 1989, 79. For every year, how many days he has been rendering his service.
My lord, and one more thing, and he has already filed an application before Labor Commission, which is pending, and this has not been disclosed in this application. Further, we have filed a reply therein, and that matter is pending before the Labor Commission.
You bring all those records.
I will bring.
But it is really a disputed question of fact how many days he has
My lord.
worked. And if his petition is pending, then there is this issue of maintainability. Let
I
him, you file a report, he will
I will
file
file
an
it.
exception. Ashwin. আচ্ছা এইটা আগে প্রথমে করুন in paragraph 3 at page 1 of the order dated September 20, 2023. It has been stated that the petitioner retired from service on August 31, 2013, full stop. However, the petitioner retired from service on August 31, 2015, full stop. Next. It is the case of the petitioner that he has been in continuous service since March 17, 1979, full stop. However, he has been regularized as a permanent employee since August 1, 1998, full stop. The petitioner's gratuity dues have been computed between August 1, 1998 till August 31, 2015, full stop. However, the petitioner should have been entitled to the gratuity dues from March 19, 1979 till July 31, 1998, full stop. Next. Learned counsel appearing on behalf of the respondent stroke employer submits that the petitioner was not in continuous service till July 31, 1998, full stop. He has been retrenched a number of times, and the retrenchment benefits have been given to the petitioner, full stop. Next. Furthermore, he challenges the maintainability of the writ petition by submitting that the proceedings are pending before the Assistant Labor Commissioner for computation of the disputed period of gratuity payable to the petitioner, full stop. For computation of the disputed amount of gratuity payable to the petitioner, considering his length of service, comma diye considering his length of service, full stop. Next. Considering the submissions of the parties and the materials placed on record, this court is of the view that a report on affidavit, R capital A capital, is required to be filed by the officer concerned of the respondent authority, respondent stroke employer, to bring on record why the petitioner shall not be entitled to gratuity dues from March 19, 1979, full stop. Next, let such report on affidavit be filed by November 24, 2023, full stop. Exception, if any, by December 1, 2023, full stop. Next. Let the matter appear for further consideration under the same heading motion bolded on December 4, 2023, bold, full stop. Serve a copy.
My lord, service of notice, may I file?
He is appearing. You're appearing in both the matters.
Both the matters.
Oh, not this. Oh, next I can do that.
My lord, in 9, the ALC part will not be there. I do not have any instruction regarding whether it is pending or not.
Acha, ekhane ashun. So from when has he joined the service? The petitioner has joined the service from August 23, 1982. From when has he made permanent?
1998 only.
Made permanent
1/8/1998.
on August 1, 1998. Retired on
31st November 2019.
2019. এখানে কোনো কারেকশনের এগুলো কিছু হবে না, কারেকশনের যেগুলো বললাম ওইগুলো হবে না। হ্যাঁ, আর ওই and he further challenges the maintainability, ওইখানে যেটা বলেছে maintainability of the ওই প্যারাগ্রাফটা হবে না। হ্যাঁ,
Grateful.
I'm for the petition. I'm for Union of India. The petitioner applied for the post of constable in CISF, my lord, in 2020, in pursuant to a notification of 2021 first, my lord. There, my lord, he completed the test and he was declared unfit by the detailed medical board exam board, my lord,
on two grounds. One is knock knee and another was a skin issue.
1 second first. Which examination did he appear for? You did not describe the examination also fully.
My lord, he was second time he has been rejected in 2023 on that is at page 54 and 55, my lord, the detailed medical and the review medical examination reports.
Page 15 is the DME.
That is the first DME in 2022. I'm not challenging that right now. I'm challenging page 54 and 55. But
1 second. The whole examination should be described in the writ petition. It's not my job to look up and find out. All right, now you come to 54.
my,
Deformity in the deformity of BL ring toe.
my lord. And second was DNS. DNS refers to a
Septum.
yes, my
Deviated nasal
yes, my lord.
septum.
Now in the review medical board has accepted the DNS and has rejected me on the point of deformation in the ring toe.
All right.
My lord, I got myself examined in the government hospital at page 56, my lord. They write, my lord, the petitioner is able to do all normal activities. That is at page 56, my lord, in the bottom of that page, my lord. Patient can do all normal activities.
You have a congenital abnormality. Look at the left side of the noting,
My
page
lord.
56.
My lord. My lord, this deformation in the toe, my lord,
Yes.
is by birth. This is not by accident or anything.
No, congenital. That's why it says congenital. It's by birth.
Yes.
Abnormality.
That I am able to do all normal activities. And secondly, this is my second application. Firstly, I applied in 2022. In that DME and the RME, this point was never raised. If this is by birth, then they ought to have rejected my application on the first occasion itself. Well, kindly comes to page 15 and 16. But 15 says knock knee and another is the skin issue. They rejected me.
Let him go and get himself tested.
Lordship, I have the instructions
Yes.
in the in the review medical exam. In paragraph number 2, Lordship,
Yes.
in the review medical examination was conducted on 25th of July 2023 by RME board consisting of 3 medical officers. Then petitioner was declared unfit due to hyperflexion of distal fannings of left 4th digit and RT 4th and 5th digit.
Paragraph number 4, Lordship. What are the limitations? It prevents the proper wearing of computerized footwear or impairs walking, marching, running, and jumping are disqualified. On this particular ground, he was rejected.
The problem is the government hospital says that he can do normal activities. So he can go and get himself tested and you see whether he can be considered to be fit for performing all these activities.
In paragraph number 5, there were a lot of decisions have been quoted in the instruction, Lordship. Dismiss these cases on merit filed against Vishnu RME. Last line of our instruction, first page also.
So you bring the decision passed by the Calcutta High Court. Bring the order. You have it with you?
No, I'm not having today.
Ashu. The petitioner participated for recruitment as a constable within bracket GD bracket closed in Central Armed Police Forces within bracket CAPF choto s bracket closed, comma SSF, comma rifleman আপনার তো এটা আছে 2022 যেটা next in the detailed medical examination held on July 22, 2023, the petitioner was held to be unfit on 2 grounds. Page 54. ওগুলোকে italics এ করবেন, হ্যাঁ, grounds গুলোকে next in the review medical examination, the petitioner was held to be unfit, bold. In the review medical examination held on July 25, 2023, the petitioner was held to be unfit on the ground of only one ground. Kore italics e kore deben. Ekhan theke ground of kore italics e kore deben. Next. Page 55. Mr. Chatterjee, learned counsel appearing on behalf of the petitioner submits that even though the petitioner may have congenital anomaly, comma, he was held to be fit, bolded, for performing all normal activities by the medical officer Department of Orthopedics, comma, Calcutta National Medical Hospital, comma, Government of West Bengal. Full stop. It was held that no orthopedic intervention was required. Full stop. Next. Mr. Khushi Proshun Chatterjee, comma, learned counsel appearing on behalf of Union of India, hands over the written instructions in court today. Full stop. He submits that lower extremities of foot and lower extremities hyphen foot and ankle uniform guidelines clearly state that presence of deformities of toes, comma, na, bracket in the acquired or congenital, bracket closed, are disqualifying factors since it prevents proper wearing of combatized footwear and impairs walking, marching, running or jumping. Full stop. Next. He submits that coordinate benches of several high courts have dismissed, italics, writ petitions filed challenging such decisions of RME. Full stop. Next. Let the matter come up for further consideration under the same heading motion, bolded, on December 4, 2023, bolded. Full stop. Next. The written instructions handed over in court today on behalf of Union of India are retained with the records. Full stop. Serve a copy. এইগুলোকে ফেরত দিয়ে দাও আর এটাকে খালি written instructionটাকে রেখে দাও. Mr. Chatterjee, it's a little difficult because the guidelines are there. It's a little difficult.
Very well.
Come back on the next day.
Grateful, Lordship.
We'll try to do something for you if possible, but if absolutely not possible, it cannot be done.
But the only point is that if this is a by birth difficult disorder, my lord, then in the first occasion itself would have been detected.
No, but then sometimes people do, it goes unnoticed, and both the examination boards held that. And it is as per their guidelines, and the court cannot substitute its own opinion. So we shall see. If possible, we'll do something.
Grateful, Lordship.
My lord, item 11, I am for the petitioner, my lord. Before
Yes.
my submission, I am praying for apology, my lord, because affidavit of service is not ready in
He's
court.
here. You are the only answering respondent.
My lord, I am appearing for the state. And
Are there other answering respondents?
office of the district judge, my lord, is answering.
So will you not represent the district judge?
Yes, my lord, this has been given by the district judge. Yes, I am representing.
You affirm it and hand it over in course of
In
the day?
course of the day, my lord, definitely, my lord. Grateful, lordship. My lord, your petitioner joined his service in 1961 as bench clerk 2 in the office of the learned additional district judge 10th Court at Alipur. In the meantime, my lord, in the year 1987, he was implicated in a proceeding. Ultimately, 2014, after his retirement, he was exonerated, and learned district judge directed the 10th Court district judge, additional district judge, my lord, to prepare a pension paper of the petitioner, my lord. Till date, he is not getting his pension, my lord. He submitted several representations, legal notices, but pension has not yet released, my lord.
From November 21, 2014, nothing has happened.
No, my lord. He was retired July 2012.
কোনো instruction is by instruction.
Lord, petitioner is suffering acute spondylitis, my lord.
হ্যাঁ, এটা জোগাড় করতে হবে। আচ্ছা, আমার কাছে।
What happened after this instructions on 21st November 2014?
My lord, I have found, my lord, there is two representations, my lord, my lord, subsequently.
What happened from your end? What happened from the end of the 10th court?
till date, my lord, because this has been given to me in September, my lord, last. I have to take some instruction, my lord. This was served, given to me in
Very
September.
unfortunate.
My lord, my lord, I do, my lord, found from
I am
the,
not saying anything to you, but I am saying the way the work has been, work is being conducted,
yes, that
the
is,
delay. In 2012, the person has retired. We are in 2023.
my lord.
And these people are like bench clerks. What money do they have to come before this court in a litigation?
That's true, my lord, but my lord, I have to take some instruction, my lord, to assist your lordship, because this is given to me in September only. I have received this copy.
The district judge has clearly directed the learned 10 court to take steps to release the pension papers.
This is affirmed on 23. So, my lord, it probably, my lord, it is served.
Very unfortunate.
My lord, I will take instruction as early as possible.
Ashwin.
He is unable to move, my lord. He is suffering acute spondylitis.
So why did you not approach the court before? What were you doing from 2014?
My lord, he was
Today you have filed it in August and you have not even completed your affidavit of service and you are saying all this. What can this court do?
your petitioner was not well, my lord.
For more than 10 years, you have not done anything. Ashwin. The petitioner. Joined service on December 24, 1969 as bench clerk -Roman 2 in the office of the learned court of learned 10th additional court. Sorry, এভাবে করুন additional the court of additional district judge, 10th court, Alipur. Full stop. The petitioner was superannuated from service with effect from July 31, 2012. Full stop. Next. By an order dated November 21, 2014, the district judge, South 24 Parganas, directed the additional district judge, 10th court, Alipur, to prepare the pension papers of the petitioner and send the same to the accountant general within bracket A and D, bracket closed, West Bengal. Full stop. The disciplinary proceeding against the petitioner since 1987
criminal proceeding.
was also
Criminal proceeding. My lord, kindly seize, my lord, the page 10.
Yes, I'm looking at 10.
Proceeding, my lord,
Yes,
is defalcation or I do not consider the continue with the proceeding as an indefinite period, considering the nature of charges which does not relate to defalcation or misappropriation of, I think.
yes,
Yes.
yes. What do you want to say?
No, my lord,
And I'm dictating the order. So without reading, why do you want to disturb? Yes. কি হলো? Dropped. And the petitioner was exonerated from charges leveled against him. Full stop. Next. Mr. Dhol, learned government advocate, appears on behalf of the petitioner, appears on behalf of the respondents. Full stop. Let a report on affidavit be filed by the respondent number 3 stroke, the learned additional district judge, 10th court, Alipur, on the issue why, despite the directions passed by the respondent number 2 stroke, learned district judge on November 21, 2014, no steps have been taken regarding preparation of the pension papers of the petitioner. Full stop. Let such report on affidavit be filed by November 24, 2023, full stop. Exception, if any, by December 1, 2023, full stop. Next. Let the matter appear for further consideration under the same heading motion bolded on December 4, 2023, full stop. Next. Motion ta bolded hobe, December 4 ta bolded hobe. Next likhun, leave is given to the petitioner to file the affidavit of service in course of the day. এটাকে না একদম প্রথম করে দেবেন, তারপরে সার্ভার কপি।
My lord, the report should be affirmed, my lord.
Yes, I have said report on affidavit. That means it has to be affirmed.
That is, my lord, if only a report is, my lord, called for, my lord.
No, let him take the responsibility.
My lord, because in 2014,
Someone
my
else
lord,
must have been there, but he has to explain because everyone has defaulted.
2014,
From
my lord, he was not there,
2014
probably he
till
was
end
not
of 2023. Yes, everyone has defaulted.
there, my lord.
It has been kept pending by all the people who were in the 10th court.
In this case, my lord, the departmental proceeding, which was arising out of a charge sheet dated 28 February 2022, was culminated with the order of compulsory retirement.
Culminated into an order of
compulsory retirement.
All right.
Thereafter, he preferred an appeal to the appellate authority. Appellate authority only modified the punishment from the compulsory retirement to the lower stage of pay scale with for a period of 5 years with cumulative effect. My lord, the charge sheet is, my lord, page 23. Charge sheet, my lord, cannot be maintainable in law because, my lord, at the time of your lawsuit, kindly come to page 23. Memorandum. At the time of framing charges, the disciplinary authority, my lord, appointed the inquiry officer and fixed the date without waiting for the reply to the charge sheet of the petitioner. My lord, your lordship knows the canon of decision of the apex court and the of our honorable high court that the petitioner is entitled to give reply to the charge sheet. He is entitled to satisfy the authority, and after considering his reply, if the disciplinary authority is not satisfied, then he will appoint the inquiry officer and fix the date of inquiry. Now, my lord, in this case, my lord, without giving him any opportunity of hearing to give reply to the charge sheet, my lord, the inquiry officer, name of the inquiry officer was appointed, and my lord, the date of inquiry was fixed by the disciplinary authority itself. Now, my lord, my second submission before your lordship that the my lord, the preliminary inquiry officer who conducted the preliminary inquiry in the rank of inspector, my lord, he himself, my lord, recommended that this person should not be retained in service and drastic action should be taken against him. page 30, the report of the preliminary report of the inquiry officer. And now in this case, my lord, the inquiry officer is also in the rank of as inspector. So both the fact-finding officer and the inquiry officer are in the equal rank. So there cannot be any fair and impartial proceedings. So, my lord, there is each and every chance of being biased. Third point, my lord, your lordship, I see that the inquiry officer acted as a prosecutor. He, my lord, being an inquiry officer, quasi-judicial authority, he, my lord, cross-examined each and every prosecution witnesses. And that cross-examination goes to the root of the charges. Being a prosecutor, he cannot, my lord, inquiry officer, quasi-judicial authority cannot, my lord, make a searching cross-examination. Page 32.
All right, let them file an affidavit. Let them file an affidavit. You're appearing?
Yes, ma'am.
Ash. In the present writ petition, the petitioner has challenged a charge sheet dated February 28, 2022, purported finding of the inquiry officer dated June 13, 2022, full stop, no comma. Show cause dated June 14, 2022, comma, punishment dated, and now an order of final penalty dated June 30, 2022, and the order passed by the appellate authority on October 31, 2022. Where is the order of the appellate authority?
My lord, lordship, kindly come. Page, my lord, 94. 92 is the order started. 94 is the last page of the penultimate portion of the order.
The appellate authority, by its order dated December 31, October 31, 2022, modified the order of compulsory retirement from service. এটাকে italics এ inverted commas এর মধ্যে হবে, compulsory retirement from service, passed by the disciplinary authority to italics inverted commas lowest stage of his pay at the appropriate level of pay matrix for a period of 5 years with cumulative effect, inverted commas closed, italics, full stop. The constable stroke petitioner was required to be reinstated in service forthwith, and the intervening period from the date of compulsory retirement till the date of reinstatement was directed to be regularized. Full stop. Next. There is no scope for passing an interim order in the present writ petition. Full stop. Next. Let an affidavit in opposition be filed by 6 weeks from date. Full stop. Reply, comma, if any, within 3 weeks thereafter. Full stop. Next. Parties will be at liberty to mention the matter for hearing, bold, hearing kothata, comma, upon expiry of the period stipulated for exchange of affidavits. Full stop. Server copy.
I am for the petitioner consider earlier occasion or
That's the statement.
allow me to withdraw the application.
Yes, there was a previous.
Yes. I mean, allow me to withdraw the application. Thank you, sir.
You pay costs.
So not as your lordship.
Now you pay costs.
As your lordship, I cannot say anything. My client has not informed me. I told him.
You have harassed all of them.
I am tendering apology because my client has not informed me. That's why I filed it. Otherwise, I will not file this application.
I have nothing against you, Mr. Sarkar, but this kind of an action on the part or conduct on the part of your client, how can the court, what should the court do? Ashu. Mr. Mukherjee, learned counsel appearing on behalf of West Bengal State Electricity Distribution Company Limited within bracket WBACDCL bracket closed, comma, submitted on the previous occasion that the present writ petition has been filed in gross suppression of material facts, full stop. In WPA 8587 of 2023, this court passed an order rejecting the same. Video order dated May 2, 2023, full stop. Such order was not brought on record in the present writ petition, full stop. Next. Mr. Sarkar, learned counsel appearing on behalf of the petitioner, tenders unqualified apology in court today, full stop. He submits that he was not aware of the fact that his client has filed a previous writ petition, his client filed a previous writ petition on the self-same cause of action, full stop. Next. In such view of the matter, WPA 21931 of 2023 bolded is dismissed, bolded, full stop. It is made clear that this court has not at all appreciated the conduct of the petitioner, full stop. Serve a copy.
No, I have for the
Only I'm paying not today, my lord, on behalf of Mr. ASG, landed ASG, my lord. Will come.
Other day also they took time. There is no
Only-
question of passing the interim order like item number 12. So, my lord, unnecessary, I believe. Here also, my lord, the award has been passed out of a disciplinary proceeding of CISF staff of ASI, appeal preferred, confirmed, or 3-stage reduction of the pay scale. Only allegation is this,
Are you coming to court tomorrow or not?
I shall, but I have one fixed matter before my justice boss.
Yeah.
All right, let me record an order today. Let me record an order and then
Tomorrow then I shall do.
কখন আছে? তো কখন আছে?
সকালের দিকে তো ওখানে তো মানে একদম
আছি তো, আমি করে দেবো কাল।
tomorrow.
Only not.
আসুন তো একটা লাইন order record.
and then I believe so subject to correction.
An accommodation is paid for on behalf of learned additional solicitor general, full stop. An accommodation was also paid for on a previous occasion, full stop. Next. In the interest of justice, such prayer is considered and allowed. Full stop. Next. It is expected that he will represent the Union of India when the matter is called for hearing tomorrow. Full stop.
Yes.
Serve a copy. নিউমেশনের এই অর্ডারটা আগে আমি সই করে দিয়ে দেবো কারণ এটা তো আজকে আপলোড করতে হবে
Much. Yes.
tomorrow under the same heading motion bold করে
Much.
Like 59 for the petition.
I'm appealing for the Public Service Commission opposing this.
The earlier occasion, my lord, the maintainability of the writ petition because the supervisor of the, my lord, the Ongani worker is either employee of the state or not, my lord. My lord, they have raised the objection, the writ petition is not maintainable,
yes
but I think, my lord, this is the petitioners are, my lord, this post is under the, my lord, the scheme. There is no government post, but they are not holding the civil post. My lord, let them learn it from, my lord, what is the one order, my lord, the ending with the division base earlier occasion.
yes he said he will he was here just now where has he gone do you know Mr. yes
Last occasion.
Mr. Tapan Mukherjee is also leading him in this matter you are also here then
May
you
I
want to
humbly submit, Lordship, that issue is not relevant for this particular writ petition, Lordship. They were talking about the scheme of the examination is of two parts. May I just indicate, Lordship? Lordship, the notification is at page 31, Lordship.
yes
The method of recruitment is of two parts. By direct recruitment, 50% of post of supervisor will be filled up by direct recruitment through a competitive examination conducted by the Public Service Commission, and B is promotion by selection. Out of remaining 50% of the post of supervisor, 45% of post of supervisor will filled up by the Anganwadi workers of Integrated Child Development Services Scheme, and rest 5% of the post supervisor will be filled up from the case worker under the controller of Vagrancy, West Bengal, through separate selection.
yes I've
test.
seen this notification
Yes,
before
Lordship. They were perhaps talking about the second part, Lordship.
no the thing is the post of supervisor is an engagement or a direct recruitment that is the thing direct recruitment for appointment
Yes, Lordship. Petitioners sat for the examination, which is part of direct recruitment, Lordship.
So that one has to see whether it is an engagement or an appointment. Is it an appointment under the
The examination is being conducted, Lordship. The scheme of the examination is at page 32, Lordship. The last paragraph, Lordship.
that is not
scheme of-
important. After when a person is appointed, just show me the do you have any one appointment letter? From there I can understand. Show me.
My lord, subject to lordship correction, my lord. Earlier occasion, they said, my lord, they are.
Wait, show me.
We only provided copies of brief. The third person who is matter, madam.
Wait.
I'm not having the brief.
One second. Let me. It is a regular appointment. Come to page 34, advertisement. You have come to page 34.
Yes, yes, yes.
From the bottom, you just see scale of pay.
Yes.
It seems to be a regular appointment because you have a proper scale of pay along with DA, HRA, all of that.
But subject to lordship correction, my lord. They are all are working under the scheme that they are the not direct appointment by the state governments, my lord.
Please try to understand
Yes.
whether by way of recruitment or whether by way of promotion. What are you participating for? You are participating for appointment to a regular post with a regular scale of pay.
Yes.
Even
that is-
by way of promotion or by way of direct recruitment, what are you applying for?
But the promotion is the, my lord, from the Anganwadi worker. to
Very
super-
good.
My lord,
For the state Union Appeal.
my lord, the issue involved this matter regarding the death benefit of postal life insurance. Yes, in falls of underground 9. May I lordship permitted to release the matter?
All right.
My lord, in this matter, my lord, last occasion, your lordship has asked to the petitioner whether it is filed in this determination or not.
All
I think that this matter should be filed in the residuary,
Under group 9.
group 9.
Ash. It is submitted on behalf of the petitioner that the instant writ petition has been wrongly filed under group 6, Roman 6. Accordingly, comma, WPA 22213 of 2023 bolded is released bolded from the list, full stop. Next. Liberty is given to the petitioner to make necessary amendments to the cost title, stroke presentation form, full stop. Next. Parties will be permitted to take appropriate steps for listing, comma, if so advised, full stop. Server copy.
My lord, one humble submission, my lord. Now, on the last occasion, an order has been passed. That order has not been served till.
There must be, there is some problem because one recording officer, she is not coming. I do not know because of that. Maybe I don't know what has happened. But dekhe nahi to hobe. অর্ডারটা আসেই নি তো আমার কাছে, আমি তো সই হয়নি দেখো, এটা তো অর্ডারই আসেনি আমার কাছে এইটা। So order has been passed, it has not been, এটা তো কি বলছে এইটা? আচ্ছা এটা গ্রুপ 3 মোশন লিখেছে, এসছেই বা কেন? গ্রুপ 6 এ তুমি দেখো তো এখানে কি। আর ওইখানে দেখো লিখেছে Are you sure an order was passed on the last occasion? Because my court officer is saying it's appearing on that day there was no order passed.
My lord, your petition, your lordship has been asked to the petitioner to take instruction.
Yes, there was no order passed. There was no formal order passed. On which date? Tell me, we will check the
26.
we will check the streaming. We shall check the streaming.
May I please, your lordship? After the
I beg to
petition.
appear for the respondent ECL.
The affidavit of service.
Yes.
It's possibly one of the shortest matters.
My lord, before my learned senior places his case, my lord, and my lord proceeds for consideration of this matter. My lord, in my humble submission, this matter is not mentionable. My lord.
All right. Why?
Yes, my lord, because it has defect of delay, my lord. It suffers from the defect of delay, and my lord, I'll be citing few documents along with judgments, ma'am.
My lord, my matter, may I start?
My lord, before he
He's
starts,
taking the point of maintainability. Yes, please. The
lord,
question of the.
this is one letter. It's connected to superannuation of the particular employee, my lord.
After he got the superannuation notice,
No,
she has
it is due, my lord. It is the notice. No, it is right after the date of filing. I believe the date of filing.
No, you do not actually listen to what the court is asking.
My lord.
What I am asking you is that is it just at the fag end of the career that the person has come for changing
Yes,
the
my
date of birth?
Yes, my lord. In this regard, I am going
So
to
that
cite-
is on merits. So he has to start.
Yes.
Yes, ma'am.
That is
But-
not a ground of delay. That is the question of merits.
On the ground.
Whether at the fag end of the career, the person can approach for changing the date of birth
Date
or
of
not.
birth. Yes, my lord.
If that is the issue, let him start.
Yes.
Yes.
My lord, I will, my lord, take your lordship to only one document.
All right.
Their document only. It is in the page 27, annexure P10, the last one. May I please request? On a proposal for obtaining competent approval for correction of the date of birth in respect of Sri Gaurib Paswan, the petitioner herein. Sri Gaurib Paswan, such and such, is an employee of JK Nagar Colliery. A petition was submitted by Advocate Mrs. Raja Satyajit Banerjee on behalf of Sri Paswan, addressed to the Director Personnel, ECL Saktoria. In this petition, it is stated that date of birth of Sri Paswan is assessed and recorded as 13/06/1964 in his appointment letter on the basis of his admit card of the secondary examination of VACV, that is Vihar School Examination Board, of the year 1984. It is claimed that the same is not correct and it should be corrected as 13/4/1968. As per the date of birth mentioned in Sri Paswan's secondary examination certificate of year 1985, issued by Bihar Vidyalaya Pariksha Samiti, Patna. In support of this claim, he has admitted admit card, secondary examination certificate, school leaving certificate, Aadhaar card, and EPIC card of Sri Paswan. The petition was subsequently forwarded to JK Nagar Colliery for necessary action in this regard. On scrutiny, it has been revealed from the office records of the colliery that Sri Gaurib Paswan had been initially appointed at the Human Project, Sodhpur area on 04/9/1984 as UG loader, and later on he was transferred to JK Nagar Colliery, Shadgram area. As per initial Form B register and the LPC received from the Human Project, his date of birth is recorded as 13/06/1964. And hence his date of birth got recorded as 13/04/1964 in official records of the JK Nagar Colliery. Consequently, the unit management decided to verify the genuineness of Sri Gaurib Paswan's secondary examination certificate from its issuing authority and thereby sent the certificate to Bihar Vidyalaya Pariksha Samiti, Patna, for his verification. YD reference number ECL JKN such and such, dated 17/03/2023. The same got verified and communicated to the unit management by the verifying authority, YD their later number 2456, dated 17/04/2023. This is also annexed. The details provided in the said letter and they mentioned and that mentioned in Sri Gaurib Paswan's secondary examination certificate are matching, and his date of birth in both the documents is mentioned as 13/04/1968. In view of this, proposal is being initiated to obtain competent approval from correction of the date of birth in respect of Sri Gaurib Paswan, UN number such and such, as 13/04/1968 in his service and all other relevant records of colliery. Placed before Chief Manager, Agent JK Nagar Colliery Mines, he has signed down there for his kind perusal and onward submission to Area Personnel Manager, Sadgram area, Sripur area, to obtain competent approval if deemed fit in this regard. So everybody has signed, it is their document. All the documents, all the supporting documents say that my date of birth is 13/04/1968. There is no single document which says otherwise, and the basis on which such erroneous date was given was the basis itself also shows that 1968, but most probably the person who was who has typed it in Bengali 8 is 4, so most probably that was the situation. And so this last document shows that all manager, assistant manager, then agent, everybody has signed it and forwarded to the area, that is the respondent number 2. It is only this there where it is now there. So my prayer is for correction of this.
So where is this document? Where is the admit card?
The admit card is, I tried to erase it here, but the admit card itself is so shady, it could not go through the process of.
So you have the original admit card?
I have the original admit card, yes.
What is it written in the original admit card?
1968. 1968,
Where is
everything
the
is.
original admit card?
I will show, and all the other documents are also, they have.
I am not concerned
Yes.
about the other documents
Yes.
because during your appointment, you have relied on the admit card.
Yes, yes.
So where is that admit card?
I'll show my.
And when did you hand over the certificate for secondary examination to the authorities concerned?
This process,
My lord,
my lord, I have mentioned that their records were being digitized. When their records were being digitized, we got to know that there was this erroneous recording, and after that
What are the documents you handed over to them?
So my lord,
appointment.
My lord, during appointment.
Yes.
During appointment, my lord, the admit card was handed over, my lord. And my
Yes,
lord,
and the admit card is handed over. The admit card is not before me. What prevented you from handing over the secondary education certificate, secondary examination certificate? That also I do not know.
no, this was the second one, P1, P2, I think. My lord, the Pramanit
When did you hand over the certificate from the secondary certificate of the secondary examination to the management?
may I say,
My
my
lord,
lord,
most
page
probably
page
2021.
23 P6, it shows that it has been issued on 31st of December 2022. My
This
lord,
is
at the bottom of the page.
Yes, it is. This is later on, obviously.
Page 23, my
Yes,
lord.
I've seen that.
See, in 2021, when the drive of digitization was started, then only we got through the process of procuring other documents from the Bihar University, the examination board. And after that, we got everything and we submitted everything. And after that, that is the last.
That is at the fag end of your career.
If it is
And you,
1968, it is
you have
not.
not brought the admit card before this.
I will bring it because admit card did not go through. I had, my lord will see that I also wrote
How
that
can
admit
you
card was there.
produce the documents at the fag end of your career and ask them to change your date of birth?
My lord, this has been going through from 2021 itself, not fag end.
It is not fag end.
My lord,
But
may I show?
2021, but we are in 2023 now.
My lord, may I show only one document, my lord, from the writ petition itself?
Nowhere
Page
nowhere
18. It is annexure P1, my lord. My lord, this document is not quite legible to me, but I have figured out at the bottom of the page, it has been clearly recorded as
per admit card.
964.
As
my
per
lord.
admit card.
Yes.
As per admit card of secondary.
It has been recorded. So, my lord, the fact remains at the time of appointment and right after that, till all these years doing service, the petitioner was well aware of the fact.
Madam, your chief manager was supposed to take a decision. Where is that decision? You
chief
did
manager,
that-
not the chief manager, area
I
personnel
just
manager.
received the brief, my lord, and based on the
Area
principle
personnel
laid
manager.
down
My
by
lord,
the
chief manager has
honorable
already taken, my lord. My lord, the
Based-
agent,
based on
chief
the
manager stroke agent JK Nagar Colliery. So
My lord,
agent JK Nagar
based
Colliery
on
has
the
already
principle
signed.
laid down by the honorable Supreme Court, my lord. I want to place two.
No, you don't have to place that because the facts are there that you have forwarded it. So where
My
is
lord,
the decision?
even if they have forwarded, my lord, I have two case references. Even if they have considered it, still it is not.
So where is the decision?
My lord, decision, my lord, I do not have a decision or any document till now. I have only oral instructions that they tried to verify the document. It was only for the verification of document and nothing else. And
Verification was done. Verification was completed.
has been
yes,
done.
even if the verification is done,
They were
the date of
satisfied.
birth cannot be changed as per these judgments, my lord. My lord, firstly, I'll be referring 2023 Supreme Court cases 411. My lord, this is past
2023 volume.
2023
No, it's a 2020.
SCC 411. My lord, may I refer to internal page 415, paragraph 9. I'm sorry, my lord. Yes. My lord, I'm placing paragraph 9. This court has consistently held that the request for change of date of the birth in the service record at the fag end of service is not sustainable. The learned additional solicitor general has in that regard relied on the decision in state of Maharashtra versus Gorakhnath Sitaram HON'BLE, wherein a series of earlier decisions of this court were taken note and was held as hereunder. Paragraph 16 particularly, my lord. The learned counsel for the appellant has placed reliance on the judgment of this court in UP Madhyamik Shiksha Parishad versus Rajkumar Agnihotri. In this case, this court considered that a number of judgments of this court observed that grievance as to the date of birth in the service record should not be permitted at the fag end of service career. In another judgment, state of Uttaranchal versus Pitambar Dutt Serwal, relief was denied to the government employee on the ground that he sought correction in the service record after nearly 30 years of service. While setting aside judgment of the High Court, this court observed that High Court ought not to have interfered in the decision after almost 3 decades. In this case also, there was a representation made in the year 2009. And the writ petition was filed in 2014. I'm referring to page 413 of this judgment, paragraph 3, which refers to the similar such situation, my lord. Internal page 413. May I please, my lord? My lord, I'll be placing paragraph 3 and 4, which says even after verification, it cannot be entertained.
Yes.
Yes, my lord. I shall be placing another judgment.
Now you show me that even after they take it up for consideration, the name cannot be changed.
Yes, my lord. Another judgment. It is connected to ACL only.
And in that regard, you read paragraph 12 of
Yes,
this
my lord.
judgment.
My lord, I shall come back with that paragraph, but before that, may I place this judgment?
Please read.
It deals with that particularly also, my lord. This is another judgment by Supreme Court.
You have to first read this paragraph, madam,
My lord.
and answer.
My lord.
And the facts are completely different. Here, after retirement, he has prayed.
Yes, my lord. In this case, another judgment. In this case, this
And
was
you have to show me that even after this, because when you are considering rectification, you might be allowed to do so. The employer might be allowed to do so. Paragraph 12 shows that.
My lord, kindly give me a second. I go through this.
You bring the judgment referred to in paragraph 12.
Okay.
Do you have a copy? That
No, I don't have a, I was not given a copy.
Yes, my lord, in this, it means
2014-12 SCC 570. Yes.
My lord, this another judgment. It is almost similar to the present writ petition. May I take?
Unreported, naকি? Unreported, naকি?
না reported. আমি দিচ্ছি তোমাকে দাঁড়াও। 2020 SCC 2023 SCC 421.
আচ্ছা, এটা
2023 SCC 421.
421.
Yes, 421. My lord, may I please particular?
Wait, 1 second.
Sorry, my lord. পুরোটাই হ্যাঁ হ্যাঁ
Yes, how are the facts similar?
My lord, here also
Paragraphs, how are the reasoning similar? Paragraphs 4, 5, and 6.
my lord, here also at the fag end of the career.
That is a
just
different thing.
before,
What
my
is the reasoning?
Yes, my lord. Not, my lord, paragraphs is nothing on.
All right, you want me to distinguish it? I'll distinguish it here and now.
Yes, my lord, my lord.
The dispute in the present writ petition is with regard to the correct date of birth of, with regard to recording of the correct date of birth of the petitioner. Full stop. The petitioner is working as an employee of Eastern Coalfields Limited within bracket ECL bracket closed full stop. His date of birth was assessed and recorded as April 13, 1964 in his appointment letter on the basis of his admit card of secondary examination of Bihar School Examination Board within bracket VSEB bracket close full stop. The admit card was of the year 1984 full stop. Next, it is the petitioner's grievance that the said recording is incorrect and his correct date of birth is April 13, 1968. As mentioned in the secondary examination certificate issued by Bihar Vidyalaya Pariksha Samiti. Full stop. In support of his claim, comma, he submitted the admit card, comma, secondary examination certificate, comma, school leaving certificate, comma, Aadhaar card, and EPIC card, full stop. Next. From a communication dated May 15, 2023, issued by the assistant manager within bracket personnel bracket closed full bracket closed and manager within bracket J full stop K full stop Nagar Colliery
As also the agent, my lord.
and agent আবার ব্র্যাকেটের মধ্যে J full stop K full stop Nagar group of mines bracket closed issued to the area personnel manager, comma, Sadgram-Sripur area, it appears that upon consideration of the aforesaid documents and the assessment and verification of the genuineness of the secondary examination certificate issued by BVPS, it was communicated to the unit management by the verifying authority. V-Day communication dated April 17, 2023, that the date of birth of the petitioner matched with the date of birth of the aforesaid documents, full stop. The same was mentioned as April 13, 1968, full stop. Next. The petitioner was initially appointed at Dhemomian project, Sodhpur area on September 4, 1989, full stop. Later on, he was transferred to JK Nagar Koliari, Sadgram area, full stop. In the initial form -B capital register and LPC received from Dhemomian project, his date of birth appeared to have been recorded as April 13, 1964, full stop. Therefore, the same was recorded as April 13, 1964 in the official records of JK Nagar Koliari, full stop. Next, the entire records were to be placed before the area personnel manager, Sadgram-Sripur area, for him to take a decision in the said for him to take a decision on the issue of recording of the correct date of birth, full stop. Next, Mrs. Banerjee, Learned Counsel, appearing on behalf of Eastern Coalfields Limited, within bracket ECL, bracket close, submits that the petitioner cannot pray for change of date of birth at the fag end of his career, inverted commas, italics, fag end of his career, oita puro inverted commas, relying on the decisions of the Apex Court of India, full stop. Next, she relies on a decision reported in 2020 within bracket 3 SCC 421 ব্র্যাকেটের মধ্যে এটাকে ফার্স্ট টাইটেলটাকে বোল্ডে দিয়ে দেবেন, to contend that even though a decision was sought for from area personnel manager, the said decision of the unit management cannot be taken into account for changing the date of birth of the petitioner. Full stop. This court finds that the facts of the said case are different from the present case. Full stop. In the said case, the petitioner's date of birth in the service record remained the same from the date of his appointment on February 27, 1982 till his retirement on March 31, 2010. Full stop. There was no occasion for the employer stroke appellants to verify the date of birth from the Bihar School Examination Board. Full stop. It was only after 30 years of joining the service, for the first time in 2009, the petitioner made the representation. Full stop. The petitioner did not avail of judicial remedy immediately thereafter, before his retirement. Full stop. Instead, the writ petitioner retired on January 31, 2010, and thereafter filed the writ petition in 2014, after 4 years from the date of his retirement. Full stop. Next, in such circumstances, the Honorable Supreme Court held that the indulgence shown to the respondent, to the writ petitioner, stroke respondent in the appeal by the High Court was not justified. Full stop. Next. She then relies on a decision reported in 2020 within bracket 3 SCC 421 bracketed mode cost title to challenge the maintainability of the writ petition on the ground of delay. Full stop. Next. To the mind of this court, the case of Ram Samuk Yadav Brolde Supra does not aid the respondent stroke ECL. Full stop. Next. In that case, 1 year prior to his superannuation, the writ petitioner raised the issue of incorrect entry of his date of birth in the service records. Full stop. He relied on his matriculation certificate for such incorrect for correcting his date of birth. Full stop. The employer did not accept such prayer. Full stop. Therefore, the petitioner approached the writ court. Full stop. Next. The Honorable Apex Court held that in 1987, when an opportunity was given by the employer to the employees to raise query, stroke dispute regarding service record and regarding entries in the pension form, the writ petitioner, stroke, the respondent number 1 in the appeal, failed to avail of such remedy. Full stop. Next. The disputed question of fact was that the respondent number 1 submission that in 1981, a dispute was raised. Full stop. There is nothing on record to show, there was nothing on record to show that in 1987, when the opportunity was given to the writ petitioner to raise such issue with regard to his date of birth in the service record, no dispute was raised. Full stop. Therefore, it was held that the division bench of the High Court committed grave error in directing the appellant to correct the date of birth of the writ petitioner. Full stop. Next. In the present case, the dispute has been raised since 2021. Full stop. The authorities themselves had the opportunity of verifying the document regarding the secondary document of secondary examination certificate, and the issuing authority certified the same to be matching with the other documents. Full stop. The unit management required it to be placed before the area personnel manager. Full stop. Therefore, the issue of maintainability of the writ petition cannot be accepted by this court. Stop. Next. This court directs the area personnel manager,
The respondent number 2.
Sadgram Sidpur area, stroke, the respondent number 2, to file a report and affidavit on the issue of why the petitioner's date of birth, the correction of petitioner's date of birth cannot be made after the letter dated April 17, 2023, issued by the BVPS. Full stop. Next. Let such report and affidavit R capital A capital be filed by December 1, 2023. Full stop. Next. Exception, if any, by December 8, 2023. Full stop. Next. Let the matter appear for further consideration under the same heading motion bolded on December 11, 2023.
My lord, one indulgence may be given, my lord. Kindly records my submission, as I have specific instruction on that, that on the date of appointment, the appointment letter contained that information, and the petitioner did not object to that. My lord, kindly records my submission.
ওই মিসেস ব্যানার্জি যেখানে বলেছিলেন না ওনাকে এইগুলো করেছে তারপরে
And during this whole tenure, he had this information, my lord. This is my contention.
Mrs. Banerjee submits that despite knowing that the letter of appointment contained the date of birth of the petitioner
My lord, page
as
80.
April 13, 1964, such dispute was not raised before the authorities concerned prior to 2021.
My lord, I'm deeply obliged.
My
This
lord,
was my instruction. I had to, my lord, bother my lord for recording this particular sentence.
Yes. You have given the judgments.
My lord.
You have done your job. I have done my job. What is the difficulty? We all have to do our jobs.
Yes, my lord.
During this time, my lord, no adverse action, my lord.
Not
made.
at all. Not at all.
I had prayed for an interim order for this.
Refused. Considered and refused.
My lord, I'm deeply obliged.
The matters you want to come, you will come. The matters you don't want to come, you will not come. Where there are instructions to be taken, Mr. Mukherjee, you will not come. What will I do? How many times will I adjourn the matters for you?
Kindly accept my apology, unintentional. I was struck off.
Yes, now you tell me. Where are your instructions?
Kindly see, but I have not been able to page 105 and 120, 130. Two improvement orders, kindly see. Page 105.
Typed copy at 105A.
5A, yes.
Yes. Yes.
In Manada, kindly see 100.
What are you showing?
113, which has been impugned in this application.
So from 65 to 60.
Because
for keeping Milord parity with those persons who are not contractual, Milord, they are well protected. Milord, for parity, how Milord this weak the contractual can be come down from 65 to 60?
Manad, your last video is a contractual employee. He's not a regular employee. And Manad, kindly see.
So how are you keeping the parity? Because you have already by your 2019 memo, you have given them till 60 years. So now how are you keeping the parity with the regular appointees by this memo?
Yes, Manada.
Because I think by your 2019 memo or 2016 memo, you had already
2014.
No, not 14.
Contractual employees.
All contractual employees were given engagement till 60 years.
Yes. Page 100.
Now, what are you improving by this memo? How are you improving their case?
Kindly see page 106 for a moment.
And one thing, Mr. Mukherjee, what is clause number 5 at page 105A?
Yes, ma'am.
Five. What is the meaning
The
of
renewal of contractual employees enlisted under the category of number 1 beyond 60 years as of now would be done with the details of the employees is submitted in the prescribed form. But that means those who are employed or on service on 1st April 20 would be dismissed with, done with the details of such employees submitted in the prescribed format.
I cannot understand. You are extending them till 65 years.
Yes, Milord, kindly once Milord, your lordship looks at page 29 capital A, once.
29.
That will Milord clinch the issue. By virtue of this memorandum, Milord, the 65 years benefit.
29 capital A, I don't
21,
have.
Milord. Sorry, 91.
Because I have
capital
the repetition is till page 31.
91 capital A. 91 is the memorandum, Milord. It's quite illegible. That's why 91 capital A is Milord the type copy.
Yes.
Yes.
Oh, this is with regard to the state Samiti.
It is in 2014.
Yes.
So this was Milord given benefit up to 65 years for the contractual employer under the scheme.
But government has every power to.
Yes, that I have understood, but how are you maintaining parity?
Madam,
You are saying for maintaining parity. I am not saying that the employer does not have the right to
Yes.
change the employment conditions.
Madam,
I am not saying.
105A, on 1st April 2020 has been clause 5.
I am asking you about clause 5. I cannot understand.
The renewal of contract for the contractual employees enlisted at the category of beyond 65 as on 1st April would be done away with, and the details of the employee submitted the prescribed form. Then, Madam, kindly see page 113.
Done once the details.
This
So you are
is for the
renewing the
medical
service
officers.
after?
This is for the medical
No,
officers.
Madam, kindly see
Category number 1. My lord,
Yes, that I have
category number 1 is medical officers.
medical officers. And
But we are the category number 3.
and other contractual posts. Madam, affidavit has to be filed, Madam. Practically, there is no scope for an interim order. Madam, if today Madam passed an interim order, he will
I
not.
am not passing. I am asking you, how are you maintaining parity? You are saying
we
you
are
are maintaining.
The other my lord, regular employment is overprotected.
Madam, kindly allow us to file a short affidavit. In the mean, your lordship can decide the disposition on merits. The government has every right to disclose this every year for the retirement age. But the government employees who is retiring 60 years. Only doctors and West Bengal Health.
The National Health Mission, what is the age limit for all these 3 categories?
That was my lord 65 prior.
As far as the central government's National Health Mission is concerned, what are the, till how long can they be engaged?
Lord, page 89 of my lord's brief, the principal secretary himself by agenda number 9, my lord, it has been fixed the upper age limit of 65 years for the employee engaged by the Samiti or on contract basis. Page 89, my lord, type copy is just thereafter. Agenda number
2013. That is in 2013.
It was done by the principal secretary. Now, my lord, this memorandum is being issued by the executive director. This is contrary to the my lord, resolution that has been adopted by the principal secretary. This
agenda number?
My lord, 9, my lord. Agenda number 9.
Fixation of upper age limit 60 years for.
All right, you file a short report and you explain. The petitioners are contractual employees engaged with the West Bengal State Health and Family Welfare Samiti, full stop. By an office order dated March 3, 2020, the upper age limit for all contractual posts other than the post of medical officers and nursing personnel was fixed at 60 years. Full stop. Mr. Mukherjee, learned counsel appearing on behalf of the petitioners, submits that such fixation of the upper age limit of the contractual employees is not in consonance with the minutes of the meeting issued by the Principal Secretary, Health and Family Welfare Department and President, Executive Committee, WB, SH and FW Samiti dated August 16, 2013. Full stop. As per the said minutes,
the fixation of the upper age limit of all contractual employees of the Samiti was fixed at 65 years, full stop. Therefore, comma, without assigning any reason, the said age could not be lowered to 60 years for the purpose of maintaining parity with the retirement age of the regular employees of the state government. Full stop. Next. Considering the rival submissions of the parties and the materials placed on record, this court is of the view that justice will be subserved by directing which respondent Respondent 8.
Just a minute.
Eight or 18?
8 or 18.
That's a blank record.
No,
File a
it would
report
be
on
better one
affidavit.
8.
Respondent number 8 stroke. The president, comma, executive committee and principal secretary. WBSH and FW Samiti to file a report on affidavit R capital A capital on the issue why the age of the contractual employees have been lowered to 60 years as opposed to 65 years, full stop. The age now, the upper age limit. Let such report on affidavit R capital A capital be filed by December 1, 2023, full stop. Exception, comma, if any, by December 8, 2023, full stop. Next. Let the matter appear for further consideration under the same heading motion bolded on December 11, 2023, bolded, full stop, sir. You don't have anything much.
I'm just praying before your lordship. If in the meantime, those person who are superannuating subject to result of the
Certainly.
Only it is
otherwise, if otherwise your lordship is of
the employer's prerogative till when the employer is going to
but the reason which has been
engage,
assigned.
but then let them come up with the reason.
Great.
I am for the respondents.
And petitioner, my lord, as per my lord's order, the petitioner already joined his post at district judge. My lord directed another matter. My lord directed the registered of the High Court to inquire the matter for anomalies. Register report দিয়েছে
রেজিস্টারটা আমাকে দেবেন
High Court.
62
ওটা রেজিস্টারকে কপিটা সার্চ করে
মোবাইল
report কি করবে
রিপোর্টটা কই? একটা রিপোর্টটা দাও। It's pending before the Administrative Committee of the High Court.
My lord.
So now the petitioner got the appointment.
Appointment.
So now it is pending before the Administrative Committee, so I'm now disposing it of. Ashok.
By an order dated May 15, 2023. This court directed the district judge, South 24 Parganas, and the chairman of district recruitment committee to immediately issue a letter of appointment in favor of the petitioner, not later than a period of 2 weeks, full stop. It is submitted on behalf of the petitioner that such letter of appointment has been issued, full stop. Next. In view of the anomalies committed by the district recruitment committee in appointing the private respondent number 4, this court directed an inquiry to be conducted by the High Court administration. Full stop. In compliance of the aforesaid direction, the learned registrar within bracket vigilance, bracket closed, was entrusted to conduct an inquiry into the matter and submit a report before the honorable court, full stop. Next. The registrar vigilance, bracketer moddhe, place the matter before the Honorable Chief Justice for according necessary permission with regard to the inquiry. Full stop. The Honorable Chief Justice was pleased to place the matter before the Honorable Administrative Committee. Full stop. The matter is now pending before the Honorable Administrative Committee. Full stop. Next. In such view of the matter, nothing further remains to be adjudicated in WPA 16132 of 2019. Accordingly, the same is disposed of. Disposed of. Full stop. Serve a copy, certified copy.
Grateful.
My lord, out of extreme urgency, my lord. Item number 170, entry order is due today, my lord. My lord was pleased to pass my
You
other
should have mentioned in the morning.
my other side is also, if kindly gives tomorrow, my lord.
This is not a mention.
My lord, I appear for the respondent. My lord, the petitioner may argue, my lord, today, but I am not having the brief with me, my lord. My clerk, my lord, there is some mistake, my lord, it is not there with me.
And on the last occasion also accommodation also sought for
My
on
lord,
your
my lord,
behalf.
he can start, my lord, if on my understanding, if there is something, my lord, I can reply, my lord, I would.
Lordship, last occasion, Lordship was pleased to direct me to hand over a copy of the report because the report was not in the file. So I have copy with me, my lord.
Please.
It's a report. And this is my affidavit of exception to the report. This was affirmed before 2020. So this is in this paper.
Yes.
UBI. That was filed by UBI, United Bank of India. And my lord, the grievance of the petitioner is that her application for compassionate appointment has been refused. And this is the second time it has been refused. In the first round of litigation, it was rejected on the ground that she is a married daughter. In the meantime, our division bench, my lord, judgment came, and accordingly, it was allowed in the favor of the petitioner, and they was relegated and directed to hear it afresh. Now it has been, my lord, rejected on the ground that there is a marginal decrease in income of the family of the deceased. Lordship, the order is at page number 45. But it says, as the fall in monthly income of the family after demise of the deceased employee was found marginal, and my application was refused. My challenge is based on two limbs. First, this order is not reasoned. That is the first ground. In the report, they have come up with certain reasons. That my last drawn, my lord, salary was 20,000 rupees, and my present income coming from pensions and other fixed deposit interest is 19,000 rupees. So, my lord, twofold, my lord, my challenge. First round is that an affidavit providing a reason cannot be taken into consideration when in a writ jurisdiction, my lord, because the reasons are not provided in the order which has been challenged in view of Mohinder Singh Gill's judgment. It's the first round of, first limb of argument. Second limb of argument is that the pensionary benefits and other retirement dues, my lord, that I am receiving, that should not be taken into consideration in case of compassionate appointment. But in this regard, my lord, I wish to rely on few judgments. My lord, if my learned friend, my lord, wants to continue today, only in that respect.
My lord, he can have his arguments if my lord so pleases, my lord. I'm noting it down. I'll come back, my lord, because I'm not having the brief with me, my lord.
All right, cite your judgments.
My lord. Lordship will first kindly takes up the report, how they deal with it. Though these reasons were not in the order. Lordship, it's at page number.
Don't have to give you reasons for
Page
rejection
number
of
3.
prayer of compassionate appointment. This is sufficient by saying that there is only a marginal drop in the income.
But
You have no right or accrued right or vested right to compassionate appointment. But it
kindly
takes
takes
what
up
you
page
want
number
to see, you please show.
Page number 3, my lord.
All right.
But it says page number 3, paragraph 3.
Yes.
This late Shamul Kumar Ganguly was an employee of the respondent bank as Doftori. He died in earnest on 4th October 2015 after serving such and such.
Yes.
And drawing a net salary of rupees 20,483 at the time of demise. And my lord, kindly comes to my lord, paragraph 9 at page number 6. Here they refer to an affidavit which I submitted before the bank. Paragraph 9 at page number 6. Here is they refer to an
Yes, there is some calculation given. 9 and 10.
calculation. They take into account this 12,000 rupees that is
Now,
pensionary
show
benefit.
The law that they
My
cannot
lord.
take that into account.
Joshua could have been. Hey, wait, wait, yes. Paragraph 6. that it says here are similar facts by place, my lord. In our view, it was totally irrelevant for the departmental authorities and the learned single judge to take into consideration the amount which was being paid as family pension to the widow of the deceased, which amount, according to the appellant, has now been reduced to the half. Are similarly placed, my lord, as me, and other amounts paid on account of terminal benefits under the rules. The scheme of compassionate appointment is over and above whatever is admissible to the legal representative of the deceased employees as benefits of service, which one gets on death of employee. Therefore, compassionate appointment cannot be refused on the ground that any member of the family received the amount admissible under the rules. As far as the question of here, my lord, this is a different ground. But in this judgment, my lord, the Honorable Supreme Court takes into account that pensionary benefits should not be taken into consideration while deciding the decrease in income of the family of a deceased.
You consider this and come back.
My lord, this pensionary benefits, my lord, was they are saying that it should not be calculated, my lord. My lord, I believe that there is a rule, my lord, which has the bank has its own rules, where, my lord, it has been stated that all the pensionary benefits and gratuity, my lord, the post-retirement benefits.
You show that is your scheme for compassionate appointment.
Lordship, I
But another point, my lord, is that
in as far as your scheme, because they will be bound by the scheme
Lordship.
for compassionate appointment,
Lordship.
whatever the scheme is.
my lord,
So-
another point is
I'll
that
put it.
the pay that has been said that it is 20,000, the term pay has been defined in the scheme itself. The scheme for pensionary scheme. May I show it to your lordship? It's a-
Ashwin, the writ petitioners challenge the impugned order by which the prayer of petitioner number 2 for compassionate appointment has been refused by Punjab National Bank within bracket PNB bracket closed, comma, erstwhile the United Bank of India within bracket UBI bracket closed, full stop. The petitioner number 2 is the daughter of an employee of UBI who died in harness on October 4, 2015. Full stop. Initially, comma, the petitioner number 2's prayer was rejected on the ground of her being a married daughter. Full stop. The said decision was set aside and the petitioner's case was directed to be considered afresh on the basis of a judgment passed by the division bench of this honorable court in respect of married daughters. Full stop. Next. The petitioner number 2's case was reconsidered
and rejected on the ground that after considering the family income of the petitioners, it was found that the fall in monthly income after the demise of the deceased employee was marginal, full stop, marginal, full stop. The deceased employee's last drawn pay was rupees 20,483, and the approximate family income was rupees 19,888,866. Full stop. Next. Mr. Chatterjee, learned counsel, appearing on behalf of the petitioners, submits that the income that the petitioner number 1 received by way of family pension, being the widow of the deceased, and also on account of terminal benefits, would not be taken into consideration for refusing appointment on compassionate ground. Full stop. The scheme of compassionate appointment is over and above the benefits of service received by the legal representatives of the deceased employee. Full stop. Next, the decision of the Apex Court is reported in 2005 within bracket 10 SCC 289. Bracketer মধ্যে cost title bold. Next. Ms. Roy Chaudhary, learned counsel, appearing on behalf of PNB, submits that under the scheme for compassionate appointment, the family income that the family was receiving month by month due to the reason of the deceased being in service of the bank, deceased employee could be taken into consideration for grant of compassionate appointment. Full stop. Next. Considering the rival submissions of the parties and the materials placed on record, this court finds that justice will be subserved by directing the respondent stroke PNB to produce the relevant scheme for compassionate appointment on the adjourned date of hearing. Full stop. Next. Let the matter come up for further consideration under the same heading motion bolded on December 4, 2023. Bold. Full stop. Server. I'm grateful. The report on affidavit and the exception thereto are retained with the records. A photocopy of the report.
My lord, I am for the petitioner, my lord.
I am for the respondent, lordship. Eastern Court.
I already completed my argument on 17th July, Lordship. If Lordship order go through 17th July, I say everything I stated in 17th July.
My lord, I would give your lordships a brief flashback, my lord. The petitioner's father, my lord, was working as a surface trammer under the ECL, my lord. He took voluntary retirement subject to the recommendation made by the board to be unfit. And my lord, he was stopped from attending his duties. Thereafter, my lord, since my family fell under economic hardship, I applied for compassionate employment. Thereafter, my lord, my father's father died on 12/3/2014, my lord. Subsequently, my lord, pursuant to the application made by my client, my lord, the assistant manager personnel Kenda area directed me to appear before the area screening committee, my lord. To that, my lord, I duly appeared before the area screening committee along with 3 others, my lord. My lord, time passed by, but nothing was communicated at the instance of the respondent authorities. But those 3 persons with whom I appeared at this area screening committee, my lord, they have been given appointment under the compassionate employment, my lord. Further, my lord, I made representation that has not been taken into consideration. My lord, a report has been filed by my learned senior friend, my lord, stating, my lord, if your lordships kindly consider page 3 of the report filed by my learned friend, senior friend, my lord. The respondent state that the compassionate appointment cannot be granted as a matter of right after such a long period of time, that is after a lapse of 9 years, 6 months from the death of the ex-employee without any good cause or merit. My lord, immediately thereafter I made, your lordship will get that because your lordship inquired from me, my lord, as to where from your lordship will get that he has, my lord, made the application soon after the death. My lord, kindly consider my exception, my lord, page 5. Annexure A, my lord. My lord, communication was made by the respondent authorities addressing to me with regard to discrepancies in some documents and my lord to file afresh. That is, my lord, on 18/4/2014, my lord.
And when has your father died?
My lord, my father died on 12/3/2014. 12th March 2014, my lord. But prior to, my lord, my father's date, I have applied, my lord, since he took voluntary retirement, my lord. And now, my lord, my learned senior friend has, my lord, placed 2 judgments in the report, my lord. My lord, kindly consider, my lord, page 6 of the, my lord, report.
Yes.
My lord, by the Honorable Chief Justice Arun Mishra and the Honorable Justice Joymallo Bagchi, my lord. My lord, kindly consider the next page, my lord. My lord, second paragraph. The facts in short indicate that the father of the petitioner died in 1994. He attained majority in 1997 and is said to have applied for compassionate appointment in the year 1997. He waited till 2007 for rejection of his claim and thereafter waited for another 5 years to file the instant writ petition before the single bench. In the facts and circumstances, compassionate appointment could not be offered as the compassionate appointment is offered so as to provide immediate successor to family to take care of the exigency which arises due to death of an employee who died in harness. And it is also settled provision of law that after lapse of a reasonable time, to say 5 years, compassionate appointment cannot be offered. My lord, he has placed that, my lord. My lord, my humble, respectful submission before your lordship is that my claim has not been rejected by the respondent authorities as yet. My lord, the facts of the case was that, my lord, his claim has been rejected. Thereafter, he has approached the honorable court after a lapse of 5 years. On that ground, my lord, it was rejected. The claim of compassionate employment has been rejected. But my claim has not yet been, nothing has been communicated till date that your claim has been rejected with regard to compassionate employment. And my lord, the very similar facts and circumstances on the, my lord, next judgment, my lord, kindly considers page 14 of the report. In the instant case, the employee died in harness in the year 1981, and after a long squabble by the dependents of the deceased, they arrived at a settlement that the son-in-law of the second daughter, who is unemployed, may request for appointment on compassionate grounds. The request so made was accepted by the personnel manager of the company, subject to the approval of the director of the company. The director personnel, who is the competent authority for post facto approval, keeping in view the object and purpose of providing compassionate appointment, has cancelled the provisional appointment on the ground that nearly after 12 years from the date of death of the employee, such an appointment could not have been offered to the so-called dependent of the deceased employee. My case is a continuous cause of action, my lord. My cause of action has not ended as yet, my lord, because my claim has not been rejected by the respondent authorities.
Yes.
My humble submission is that it is the lapse on the part of the respondent authorities. This is not the latches on my part, because I applied in the year 2014, 2018, I was called for screening, my lord. Thereafter, no communication has been made today, my lord. Neither my claim has been rejected, my lord, till date.
Where is the impugned order? Where is the impugned order?
My lord, order of rejection.
What is the last communication?
The
Page
last
16.
communication is at page, my lord, annexure P3, page, my lord, 16. I was called for
Page
screening,
16, that's what I'm asking.
my
you.
lord, page 16.
And when have you answered to their letter? At page
No answer.
16.
No answer. No answer. Lordship,
No, my lord, I have,
with the exception they annex a document, they did not submit all the document till today.
No,
Where
I
have you
cited
answered to page 16?
My lord, I appeared before the screening committee. There, I have, my lord, submitted all the relevant documents, my lord, on that day.
From where will I get it?
My lord, that must be with the records, my lord, their records. Because, my lord, I have submitted all those documents, my lord. And my lord, all these 4 were called on that day, my lord. 3 have been given upon.
Have you produced the minutes of the meeting before the screening committee in your report?
No, Lordship. There is no
Why
such.
not?
Lordship, on 14th, in 18 exception, they have asked to submit the report document. They did
Have
not
you
submit
produced the minutes of the meeting dated January 11, 2018?
No.
Why not?
There is no such direction. I'm not.
So in the report, what will you do? If you do not try to resolve the issue, what will you do?
Lordship, he has not submitted all the record. From the exception, it is clear. If you did not
Have
submit
you or have you not produced the records of the minutes? Then everything will be clear from the records of the minutes of January 11, 2018.
Lordship, then I will produce. Lordship, he has made the presentation after 9 years, in 2022. He did not submit all the record as per the exception. Problem
Sorry,
is,
that I cannot accept. Ashu.
Lordship, one unreported judgment of Justice passed by Justice Dipankar
Yes,
Datta
all
is
the
cited.
three unreported, reported and unreported judgments I am going to distinguish now, here and now for your convenience. Please listen to the order. The petitioner's father was declared unfit boldly for employment in January 2014. Full stop. He was an employee of Eastern Coalfields Limited, within bracket ECL, bracket closed, full stop. The petitioner made an application for compassionate appointment. Full stop. Thereafter, the petitioner's father died in March 2014. Full stop. In the exception to the report filed on behalf of the petitioner, a document dated April 18, 2014, issued by the manager within bracket personnel, bracket closed, comma, Lower Kenda Colliery, has been annexed. Full stop. From the said document, it appears that the petitioner that requisite documents have been called for from the petitioner since certain discrepancies were observed while scrutinizing the proposal for employment forwarded by the petitioner's father and mother in his favor. Full stop. Next. What are you doing? If you keep on disturbing the court, how am I going to dictate the order? Take the actor. Mr. Kumar, learned counsel appearing on behalf of ECL, submits that an application for compassionate appointment has been made more than 9 years after the petitioner's father was declared to be unfit boldly by the respondent company, respondent ECL, full stop. Therefore, comma, his prayer could not be considered by the authorities. Full stop. He relied on several judicial precedents in support of his contention. Full stop. An unreported decision of the Honorable Division Bench dated February 12, 2013 of this court, within bracket, cost title ta kore deben, is relied upon, full stop. With due respect, comma, at a next also. The facts of the said case are distinguishable from the facts of the present case, full stop. In that case, the father of the petitioner died in 1994, and he made an application for compassionate appointment, and he made a purported application for compassionate appointment in 1997, full stop. He waited till 2007 for rejection of his claim, full stop. Thereafter, comma, he waited another 5 years for filing of the writ petition, full stop. On such facts, the Honorable Division Bench held that compassionate appointment could not be offered, since the very purpose is to provide immediate succor to the family to take care of the exigency that arose due to the sudden death of the employee. Full stop. Next. He then relied upon a decision reported in 2009 within bracket 13 SCC 112 ব্র্যাকেটের মধ্যে এটা করে দেবেন, কস্ট টাইটেলটা বোল্ডে করে দেবেন। In that case, it was held that the deceased employee, comma, died in harness in 1981, and after a long squabble, the dependents of the deceased arrived at a settlement as to who may request an appointment on compassionate ground, full stop. Therefore, comma, due to delay in approaching the authorities, the provisional appointment was cancelled by the employer, full stop. Therefore, comma, the Honorable Supreme Court found no infirmity in cancellation of such provisional order, full stop. Next. Next, he relies on a judgment, on an unreported judgment of a coordinate bench of this Honorable Court dated April 17, 2009, ব্র্যাকেটের মধ্যে কনস্ট্রাক্টটা বলবে, full stop. In that case, the father of the petitioner died in harness on June 20, 1987. Full stop. The petitioner did not disclose when the application for compassionate appointment was filed. Full stop. Had it been filed when he was a minor, his name should have been entered in live roster according to the terms of National Coal Wage Agreement, within bracket NCWA, bracket closed, and his claim should have been considered when he attained majority, full stop. Next, because of the lack of information on the point at which the petitioner made an application for compassionate appointment, comma, the information which the petitioner should have provided, comma, the respondents could not be held guilty for not performing their duties, full stop. The decisive factor was the distance in time between the date of the death of the petitioner's father and the approach made by him for compassionate appointment, full stop. It is such distance that tilted the scale against the petitioner, full stop. Next, tilted the scale against the petitioner. Next, in the present case, the petitioner has made an application. The petitioner's father has made an application being unfit, bolded, for compassionate appointment of his son in 2014 itself, full stop. The discrepancies in the documents were noted by the authorities in 2014 itself, full stop. Therefore, comma, this court finds no substance in the argument that there was a significant distance between the date on which the petitioner's father was found to be unfit, bolded, and the date on which an approach was made to the ECL authorities for compassionate appointment, full stop. Next. The petitioner refers to a document annexed to page 16 of the writ petition, full stop. He was called for screening on January 11, 2018, along with 3 other persons, full stop. All the 3 persons called for screening on January 11, 2018 were appointed on compassionate grounds, full stop. However, comma, no communication was made to the petitioner regarding the fate of his application. Full stop. Next. Mr. Kumar is permitted to bring necessary instructions as to instructions annexing the minutes of the meeting dated January 11, 2018. Full stop. Why the petitioner was not granted employment when 3 other candidates who were also called for screening on the same day is required to be explained in the said written instructions. Full stop. Next. Let the matter come up for further consideration under the same heading, motion, bold, on December 4, 2023, bold, full stop, server copy. You have 1,000 rupees costs for filing the report, so don't take more time to file the written instructions.
No, Lordship, from today, hormone will be injected to me. I do not know from tomorrow I will be able to appear or not. Hormone therapy.
You will be able to appear. So now
I do not
get better by November and you bring your instructions by
No,
December.
yes, by November, Lordship. From today, the hormone therapy is started from today.
All right. We'll see you in December.
Great.
I am for the respondent led by Mr. L.K. Gupta, my lord.
Yes, yes.
After his wife enjoying the pension, family pension, and my mother and thereafter I applied as a divorced daughter.
Yes, yes.
Earlier, there is a scope for considering the divorced daughter, their own. But 2005, they adopted the rule 54(6) of the CCS.
But they said that the whole, it is not permissible for all the categories. That is what they are saying. By their office memorandum, that's what they are trying to say.
They are advocating in opposition the resolution. I will rely on their resolution. The affidavit, my lord, affirms on my lord. February, or February, May 2020. They manage their own resolution.
Which, please tell me the date of the affidavit.
Date of the affidavit, 3rd May. Affirmed by Subroto Kumar Das.
এই অমিতাভ একটু দেখো না কোথায় অ্যাডিশনাল অ্যাফিডেভিট গুলো পাচ্ছে
Affirmed by 3rd May. March.
July.
That is 3rd March.
July. ও আগে অ্যানেন্স করেছি এটা।
আপনি 3rd March.
3rd March, আবার 3rd May বললো।
Correction.
অ্যানেক্স স্যার বলো, ওটা অ্যানেক্স স্যার। আমার এফিডেভিট দিতে বলো।
Affidavit in opposition.
3rd March.
দেখো তো 3rd March, ওটা তো 3rd March, no, এটা তো অগস্ট। অ্যাডিশনাল গুলো তারপর সাপ্লিমেন্টারি। I'm getting the additional ones, I'm not getting the main one. Just wait.
3rd March.
Third March. সাপ্লিমেন্টারি না, সাপ্লিমেন্টারি তো পেয়েছি, আর পরে ওটার পেছনে রাখো। এটা হবে মনে হয় লাস্ট। Yes. Yes, yes.
Paragraph 6. Their statement, they have stated that report 6 of CCS they have adopted and my lord. Eligible cases that to follow the deputy chair. Station is page 9. Board resolution.
Page 9.
Regulation number 19 dated 30th March 2015 resolved that provision of the cure of which table as 6 of this hereby included under the definition of family. If it is included in the definition of family, what rule 54 this, my lord? 54(6). My lord, I am handing over the my lord. Handbook of is the handbook of DTS. Well, kindly come to the page 7. What number is what? Page 7.
Yes.
Page 7, heading serial number 5. Eligibility of divorce, widow, unmarried daughter.
But I do not think they are saying that you are not eligible. They are saying that there is extreme financial constraint. That is what the tenor of their argument is.
That cannot be a ground. Let them sanction. Thereafter, they will ask their body, parent body.
And I also ask them to take necessary instructions who will bear the additional expenditure. The Union of India or CDLB.
Not a case of revision of pension. This is case of disbursement of pension. Let them first disburse it. Since the family definition of family included divorced daughter, I am entitled to get. That kind of chairman approval is necessary as per their affidavit. Let them sanction after approval of the chairman. Ancient practice cannot be ground for disbursement of the pension, family pension. These board adopted the rule 54(6) of the CCS pension. Definition of family, I also, my lord, handed over a order of the central government. They directed the authority, my lord, take a note of family, definition of family as per rule 54(6) of the CCS pension.
that communication dated February 5, 2020, issued by the Undersecretary.
There also, my lord, definition of family, my lord, was indicated. As per the rule 54(6). Rule 54(6) of my lord pension rule provide diverse daughter to get pension. It was introduced long back, my lord, 1999. Thereafter, all the state government and all the, my lord, undertakings adopted the, my lord, 54 rule 54(6). All departments.
Yes. Yes, I'll come back to you in reply. Let Mr. Gupta submit. Yes.
Question is whether definition of family diverse daughter they are not. If my lord included in their own rule, then I
This is not a case of dying in harness. After retirement, the employee died, he was on pension.
Yes.
When he was drawing pension and died, my lord, his widow was given pension, and that continued up to February 2021.
All right.
Now, the daughter who is now the petitioner, she was married and then got divorced. That was also in 2021 after the death of the mother. This is the scenario. Now the question is whether she will be entitled to get the pension in respect of her deceased father.
Family pension in respect of a deceased father.
Now, my lord, with regard to that, there are two provisions. One is applicable to class 1 and class 2 staff of central government and undertakings, which provides that yes, divorced daughters will be entitled to get family pension. Now there is another set of provisions which is called WRC. WRC, that is workmen's scheme. So as per that, you know, that applies to workmen only, not class 1 and class 2 officers or others, but only to workmen. Now, as per that, there is a provision also, my lord, which categorizes, my lord, the set of employees into two. One is, my lord, that says who will come under class 1 and category 1, and who will come under category 2. Now, my lord, if your lordship kindly takes up our affidavit in opposition. Kindly take this main affidavit, which is affirmed by Subrata Kumar Das on 3rd March 2023. Annexure 1, R1, I am referring to, which starts, my lord, at page 6. Kindly take page 7.
Yes.
Page 7, my lord, towards the end. As per WRC 2007, the category 2 comprising unmarried, widowed, divorced daughters and parent as applicable has been brought under the purview of family pension with effect from 1/1/2007. Board has not yet implemented this category in the sphere of CDLB till date in absence of affordability. Board is presently disbursing family pension to the incumbents under category 1 as per said WRC 2007 as follows. Now, category 1 is this, my lord, ABC dates, widow or widower up to date of death or remarriage, whichever is earlier. Then B, sons, daughters, including widow daughter, up to the date of his or her marriage or remarriage, or the date she starts earning, or till 25 years of age, whichever is earlier. The widow daughter, my lord, till 25 years or till remarriage. That comes under, my lord, this category 1. We are disbursing, my lord, family pension to this category, category 1, but not to category 2. My lord, the reasons why we are not being able to disburse this, in spite of WRC 7, my lord, I have elaborately discussed that in my affidavit. The reasons are, my lord, that we don't have the financial capacity to do this. My lord, I have outlined, my lord, the income that you earn is 5 crores per month. And out of that 4.9 crores are spent, my lord, on wages and pension and administrative expenses. Now, what is the position of pension? My lord, we have 38.
Is that all you have described in detail?
Oh, your lordship has seen that.
Yes, on the last occasion also, and your junior also placed when the first time the matter came up.
Yes.
She
Now,
also
my lord,
placed
this,
that.
My lord, this is the position. We don't have any property or anything. We cannot, my lord, sell the property and pay anybody. My lord, whatever our earning is, we are spending almost the entire thing on
No,
this.
but as far as the directions of the government are concerned, you have to show that
There is no
it
direction of the
requires
government.
not CCS pension rules. You have to show that an additional approval is required by your board for such
We have separate
implementation.
pension rules. We have separate pension rules.
Sure.
Yes. My lord, if your lordship kindly takes power this affidavit. The supplementary affidavit filed by us.
If you look at page 9 of this main affidavit,
Lordship.
resolution 19 of dated March 30, 2015.
Lordship. Yes.
Page 9, resolution 19A.
Resolution 19A, yes. Resolution 19 dated 30th of March 2015 resolved that provision for the period for which family pension is payable as in Rule 54(6) of the CCS pension rules is hereby included under the definition of family in the board's pension rules for workers and employees in terms of the note circulated on the item. Definition of family is included in our rule also. It is also included.
No, but then you have adopted this provision of Rule 54(6).
Yes.
Of CCS pension rules. This is your own board resolution.
Yes.
And it is applicable not only for employees, but also for workers.
Yes, for employees, yes, and workers. Workers and employees.
Yes.
Yes.
So now today a distinction cannot be made between the employees and the workers.
Even with regard to, no, the distinction can be made because with regard to category 1, category 2, they come under different heads. They are
here you clearly say
employees are not 1 and 2 category.
No, you say the rules as per 54(6) of CCS pension rules are applicable for workers and employees.
Yes. Therefore, I cannot dispute that, my lord, we had.
Maybe amended suitably.
Is hereby included. But we cannot dispute that there was a duty. As my lord, we have the duty, my lord, also to pay the pension as is being enhanced from time to time.
Yes, on one occasion you said that the eligibility may not be in dispute. But the question is whether you have the financial strength.
Exactly, that is our entire case. We do not dispute, my lord, that I cannot say my learned friend's client is not entitled to it. But my lord, we are not in a position, my lord, financially to pay this. This is, my lord, the entire submission in our affidavit. And we have stated, my lord, there were several directions of the court, pay them.
Yes, but that if they can't pay that, even the decisions you cited, the orders you cited in contempt is that it's not that the eligibility was disputed.
I'm not
Your
saying-
inability to pay, because of
Exactly,
your
that's my-
inability to
that's
pay,
my
the
whole case.
contempt application may have been dropped,
Yes,
the contempt proceeding.
I will be happy, my lord, if the central government comes up today and, my lord, helps us in getting more finance. Because what has happened, my lord, throughout the country is there are 7 ports, major ports. And in respect of each port, there was a dock level. In respect of all the other 6 ports, the concerned dock level boards have been merged in them. And only, my lord, in case of Calcutta dock level board, this has not been done by the central government. In earlier proceedings, my lord, the Honorable Court had directed the then Solicitor, the Additional Solicitor General to come to appear before their lordships and to take, my lord, steps to approach the central government to provide funds. My lord, the Additional Solicitor General said, my lord, that the government is not in a position to do this. That is,
Yes, I had asked Mr. Bhattacharya also to take instructions.
We have not received an instruction.
Very good. You take instructions after 2-3 years.
my lord, the same instruction will come because we have been fighting, my lord, for so many years. My lord, we are fighting, my lord, with the central government. We are making various requests to the central government from time to time. But, my lord, the response is never coming, or it is always negative. That is the position, my lord. Therefore, my lord, I will only submit this, my lord, that the courts do not pass orders, my lord, which cannot be implemented. This I say, my lord, because
But also inability of an employer to pay will not
that is one aspect.
not rob the employee or the pensioner from
My lord,
their right.
absolutely, yes, my lord, and we would be possibly the happiest employer if we could provide this. Because we feel, my lord, whoever are instructing us, whoever are there in position now, they will all be affected in the same manner. All of them will be affected in the same manner. It's not, my lord,
Now,
that
at
they
least
want-
let it reach a conclusion before the single bench.
Lordship.
Let it reach a conclusion before the single bench.
And, my lord, since there are 4,000 plus pensioners, this situation, my lord, will come with regard to many. 38 employees and 4,000 pensioners. This is the position. And we'll have to deal with this, my lord, not in one case, but in so many matters.
But unless this court passes an order, it cannot be tested.
No, that is
One
true.
day or the other, it has to pass
That
an
is
order.
true. One way or the other, my lord, thinking loudly, supposing your lordship directs us to make it. My lord, my lord, I have disclosed the accounts before your lordship.
Yes.
That's my predicament, nothing else. That's my predicament. I conclude.
Ashu. Yes, yes, give your appearance. The petitioner is a divorced daughter of an ex-employee of the Calcutta Dock Labor Board within bracket CDLB. Bracket closed, full stop. The petitioner's father died on January 14, 2016. Full stop. The petitioner's mother thereafter received family pension. Full stop. The petitioner's mother died on May 4, 2021. Full stop. Next. The petitioner's marriage was dissolved by way of a decree of divorce dated March 31, 2021. Full stop. Uh, 3rd July 2019. Full stop. The petitioner claims to be a dependent of her mother and therefore entitled to family pension. Full stop. Next. Mr. Das, learned counsel, appearing on behalf of the petitioner, submits that the petitioner is eligible for family pension under Rule 54 within bracket 6 of Central Civil Services within bracket pension bracket closed rules, comma 1972. Full stop. Under Rule 54 within bracket 6 now, Rule 54(6) of CCS rules is set out hereinafter. এটাকে না এখান থেকে এই অবধি italics এ করে দাও। Next. Mr. Gupta, learned senior counsel, appearing on behalf of CDLB, submits that the eligibility of a divorced daughter to family pension is not in dispute. Full stop. However, due to severe financial constraints suffered by CDLB, the divorced daughters cannot be.
But one thing, when I do not dispute the eligibility, kindly refer to me my resolution at page 7 in supplementary affidavit, which says that board resolution is that we are not in a position now to implement category 2.
কি হলো?
Page 7 of the main affidavit.
Due to severe financial constraints that the board is suffering, the divorced daughters cannot be brought under the purview of the word dependents who are eligible for grant of family pension. Full stop.
My main affidavit, page 7 bottom. Page 7 bottom. There is
Next,
a part of
Mr.
resolution
Gupta,
dated 30th March.
Mr. Gupta also refers to the resolution resolution number 8 of the board meeting dated March 30, 2015, to submit that as per WRC 2007, the category 2, Roman 2, comprising unmarried, widowed, divorced daughters and parents as applicable, has not been implemented by the board of CDLB till date due to the absence of affordability. Full stop. As per WRC 2007, category -Roman 1, comprising of widow or widower, up to the date of death or remarriage, is being granted family pension. Full stop. Next. Therefore, he submits that family pension for the divorced daughters should not be directed to be paid at present. Full stop. Next, Mr. Bhattacharjee, Learned Counsel, appearing for Union of India, was permitted to bring necessary instructions as to the funds that may be provided by Union of India to CDLB for payment of family pension. Full stop. Family pension to widowed daughters. Full stop. Till date, no instructions have been brought on record. Full stop. Next. Where is the order passed in contempt that you relied on? Oh, all right, I found it. Mr. Gupta also relied on an order dated April 7, 2017, passed in CPAN 780 of 2015 by the Honorable Division Bench of this court to submit that contempt proceedings have been dropped against the officials of CDLB, since it was held that the said officials did not have the money or access to the money to make the necessary payment to the applicant, who was one of the thousands of retired employees of CDLB, seeking benefit of a revised scale of pension. Full stop. Next. Since it was apparent that CDLB did not have the means to pay the pension at the enhanced rate, the violation of the order of court appeared neither to be willful or deliberate. Full stop. Therefore, comma, the Honorable Division Bench dropped the contempt proceedings. Full stop. Next, এইবারে মিস্টার ভট্টাচার্য যেটা বললাম না ওই প্যারাগ্রাফটা এবারে দিয়ে দেবেন। Next. Considering the rival submissions of the parties and the materials placed on record, this court finds that by resolution number 19 dated March 30, 2015, the provision for family pension as applicable, the provision for family pension was the provision for the period for which family pension was payable as per Rule 54 within bracket 6 of CCS within bracket pension bracket closed rules was included under the definition of family, inverted commas and more, in the board's pension rules for workers and employees. Full stop. Therefore, comma, this court finds no reason for not considering the case of the petitioner as being eligible, italics, for payment of family pension as per Rule 54 within bracket 6 bracket closed of CCS within bracket pension bracket closed rules. Full stop. Next, to the mind of this court, the affordability of a pension, affordability of an employer for payment of pension stroke family pension cannot be taken into consideration while assessing the issue of pension stroke family pension payable to an employee stroke legal representative of an employee. Full stop. Next. It has been held by several decisions of the Honorable Apex Court that pension is not a bounty. Full stop. Therefore, financial stringency of the employer cannot be considered for determining whether or not, for determining the issue, whether or not the petitioner is eligible for pension. Full stop. CPAN 780 of 2015 arose out of FMA 1709 of 2013. Full stop. In FMA 1709, the petitioner's entitlement to enhanced family pension must have been directed to be paid, full stop. Since the enhanced amount was not paid, the contempt application being CPAN 780 of 2015 must have been filed, full stop. Therefore, comma, despite the financial stringency, stroke affordability of CDLB, FMA 1709 of 2013 was decided in favor of enhanced pensionary benefits being paid to the petitioner, full stop. Next. In the light of the discussions herein above, WPA 9617 of 2022 is disposed of by directing. Where is your representation? Hmm? 16. By directing the Assistant Administrative Officer, stroke, comma, CDLB, to consider the representation of the petitioner dated November 2021 within a period of 6 weeks from date upon giving, upon giving a personal hearing to the petitioner and in the light of the observations made herein above, full stop. Next. A reasoned order shall be passed and communicated to the petitioner within a period of 2 weeks from the passing, within the period of 2 weeks from the date of the hearing, full stop. Next. আর তারপরে সার্ভার কপি সার্টিফাইড কপি আর ওটা ডিসপোজড অফ আর WPA নাম্বার গুলো বোল্ডে হবে। This could have been the only conclusion, because in FMA also order was passed. Maybe it was not implemented, but then the entitlement could not be denied.
No, that is not on the basis of this order. We have been doing it, and the government has repeatedly rejected.
But what can the court do? It could just affordability will not do, even if the eligibility cannot go away. Her entitlement cannot
But
go
the
away.
only thing is, my lord, so far as our position is concerned, my lord, if we don't have the means to pay, where from do we pay? Well, even by selling anything, because the office, our office is constructed on a land belonging to the port trust.
You have to write to the central government to release funds.
That we have, in our affidavit also you have said. And my lord, the honorable division bench, my lord, even directed the additional solicitor general to take personally to take steps with the central government. And that is also
Now central government is no more coming. They have gone away. Appearances noted, central government is not coming to give their instructions anymore. For so many days, I have been asking them to take instructions. Where are they? No one is giving instructions. This matter has been heard on several occasions.
The central government has to take a call, not only with regard to any particular matter, but with regard to assisting this CDLB to work properly, either on the basis of merger or whatever, or by providing necessary funds. Your jobs have
Now they will not come anymore. Now this is disposed of. I have given them several opportunities. Now they will not come.
no, they will be again. They can be called again in the contempt.
Yes.
হ্যাঁ নতুন করে যাই
অর্ডার পাস করবো কন্টেম হবে না ফেজ হিট হবে আবার
Not today. I think it is appearing wrongly today. It will be taken up tomorrow.
A report as per your lordship.
Is it appearing correctly today? Please answer
Petitioner
that.
is also there, my lord.
He may be. Look at the order. I do not know. I haven't seen the order. My court officer
Rightly,
is
I
saying that
don't-
it is supposed to appear tomorrow.
Yeah, 6 weeks.
It is supposed to appear on the 10th,
Yes.
not on the 9th. Come back tomorrow.
Well, I beg to appear in the
I cannot hear you. Speak loudly.
Your Lordship, in this matter, Mr. Ritesh Ganguly is appearing. Your Lordship, he's on his legs in a different court. He has asked me to seek for an accommodation for the day.
16th.
before this side of the vacation.
16th.
This side of the vacation, my lord.
You don't want one only for one day. He wants. You will be here on the 16th. Where will you go away before the
No,
vacation?
16th is the Monday.
Yes.
Monday I'm some difficulty.
Then I do not know when I will be taking up returnable motions. Monday is probably the last day I'll be taking up returnable motions.
Wednesday, my lord.
Impossible. Thursday we are closing next week. This Wednesday, I can keep it on this Thursday,
Thursday, sir.
12th.
Deeply obliged, Your Lordship.
Would you not give some direction to the central government in this regard? Or you are giving us liberty to approach the central government?
All right, that I shall. When I correct, I shall.
That right. We definitely feel, my lord, for the employees. But then not.
I have indicated that I have asked them to bring necessary instructions and still they have not. That I have indicated.
Add one.
You want another line with regard to you approaching the central government? That I should consider.
Manor 68, Manor, I am for the petitioner, Manor. Manor, on the last occasion, your lordship gave me leave to file a supplementary affidavit, Manor. I've already served the answering respondent, the corporation, Manor.
You are
Manor, I am
appearing,
appearing on
Mr.
behalf-
Mukherjee?
My lord, I am appearing on behalf of the SC/ST Finance Corporation.
Yes.
On the last occasion, there was an instruction, my lord, to produce the scheme of merger, my lord. My lord, I have handed it over.
Now, they are the members of the Employees Provident Fund Act 1952.
So your submission is that there is no scheme for payment of pension.
The income retirement benefit scheme of the West Bengal is not applicable to it, or the corporation has not framed any scheme, or the employees of the West Bengal Scheduled Caste and Scheduled Tribes Development Corporation Limited.
My lord, my case is that, my lord, I have not been given the notional benefit, and also, my lord, my provident fund has been deducted. I am an employee since 2008, my lord, and my provident fund has been deducted only in 2018 after merger. That is EPF, my lord, and before that, my lord, I have made several representations. That was not considered, my lord. Subsequently, my lord, by the supplementary affidavit, my lord, I placed on record some documents which I don't ought to not have, my lord. But in there, my lord, it has been clearly stated in the finance department that there has been an irregularity in maintaining the service book, and he has his POS contribution has not been deducted, my lord. My lord,
Where is it?
May I please page 4, my lord, of my supplementary affidavit, my lord, today, which I have filed today, my lord. It are not our instructions. Yes, yes,
This is with regard to that post facto, my lord, his notional benefit that he has to be given from 1999, my lord. He was absorbed in 2009, but my lord, according to the cabinet decision, my lord, his post facto approval should be from 1999. That was not given to him, my lord. Thereafter, my lord, page 17, my lord. Page 7, my lord, of my submission. I'm sorry.
Page 17.
Page 7, my lord. Page 7, my lord, is the irregularity is a query from the audit finance, my lord, where it has been stated that irregular maintenance of service record and non-deduction of GPF subscription. May I read it? The next page is also, my lord, same, my lord, non-production of personal file and non-deduction of GPF subscription.
Okay.
It is.
So what has the corporation been doing? Several intimations have been made to the corporation.
My lord, I like to hand over. My lord, kindly see. There is no scheme as such, my lord, to provide the pension benefits to them.
But his PF also has not been deducted, now. Nothing has been done with this.
Have you look at the supplementary affidavit, page 7.
Supplementary affidavit service coverage.
Until unless he challenged the statute itself. When it is called West Bengal Scheduled Caste, Scheduled Tribes and Backward Classes Development Corporation Limited 2017. And
No, what I am saying is that if the managing director would have clarified, all these letters are being written, if he would have clarified, the issue would have been put to rest.
Section 33 of the kindly see the 30.
1 second, let me just see this response by the corporation.
Page 7.
When it was taken over, enactment, but there was no such provision for payment of pension. Section 33 has not been done. Okay.
Yes, which section?
Section 33, receiving and serving. Subsection 3, small c.
Section 33.
33 small c. The kind of subsection one, the West Bengal Scheduled Caste and Scheduled Tribe Development Finance Corporation Limited and West Bengal Classes of Development Fund Corporation 95 hereby repeat. Notwithstanding such repeats, anything done or taken under the Scheduled Caste Act shall be deemed to have been valid done under that. Then upon such repeat, section, all officers and other persons in employment of the corporation under the Repeal Act immediately before the commencement of the act shall until any other provision made continue in service. Corporation as
Mr. Mukherjee, speak on the microphone. I can't hear you.
corporation of the and shall hold the office service thereunder by the same tenure to the same remuneration upon same terms and conditions with the same obligation and with the same rights and privileges at the leave fair concessions, welfare scheme, medical benefits, insurance, provident fund and other funds, retirement, voluntary retirement, gratuity and other benefits as held by him in a corporation under the Repeal Act shall continue to be as an officer as the case may be other employee of the corporation or until the expiry of 6 months from the date of corporation of this act. If such officer or other employees opts not to continue the officer or the corporation. But there is no such provisions for payment of pension. Leave fair concession, welfare scheme, medical benefit scheme, insurance, provident fund, and other funds. And section 3.
Please show me the notification of September 9, 2009.
Just give me one.
Madam, you show me the notification of September 9, 2009. Clause 2(8).
In that case, I'll come back tomorrow. 2009.
You look at the page 3 of your instruction. Page 3, paragraph 5. Instruction. 4th line from the top.
Nice.
Because from all the documents that the petitioner has annexed, all the board resolutions of 2017, one can see that you are saying that the service conditions of the peon the petitioner has not yet been formulated. These are the letters of 2013 and 2017. That is, service conditions have not yet been stipulated, fixed, finalized.
The corporation has not framed any scheme for payment of pension.
Corporation is saying that it is not yet finalized. The service conditions are not yet finalized. But the corporation is heavily relying on this memo of September 9, 2009. But I do not find that memo in the written instructions.
No, that.
Malad, I'll
the
come back
memo,
tomorrow.
The statute will prevail over everything. After that enactment has been made 2017, everything goes.
That is very good. But then this person is in employment since before that.
What a kind of thing? When it was taken over by legislation, 2017.
This is the word. What is the effective date?
Effective date, just give it. Appointed date is.
And will it be applicable with retrospective effect? You have to show me that.
Appointed date is, the appointed date is 6 November 2017.
So he is working much before that.
2008, since
When it was taken over, there is no mentioning about the paying of your pensions.
Yes, maybe, but then if that person was already eligible to get pension, how can you take away the right? This statute is not applicable with retrospective effect. And the managing director, they are saying in 2013-17 that it will be fixed, it will be fixed. Even in 2017, they are saying it will be fixed.
But when it was enacted, no scheme was there. And the pension has.
But is it applicable with retrospective effect? That you have to show me, Mr. Mukherjee. I have to apply my mind to that.
Can you see the date of appointed date is 6 November 2017.
Yes, but then this person was already working then.
2008, since 2008.
Right. I think a minor friend was appointed in 2008.
Yes.
But 2009 it was taken over. Under section,
where do I get the appointed date from?
This is the notice. Appointed date notice. Can you see section 1? Extend the whole of West Bengal, 1 subsection 3. It shall come into force on such date at the state government, but shall be appointed. Section 1, subsection 3. Have you not got it?
15th November 2017.
Yeah. And section 33, subsection 3, there is no such provision for payment of pension or anything.
That I have understood, but you please
Yes,
produce that notification. Ashwin.
September.
You are still working?
Yes, no, my lord. He has retired in 2000.
When?
2022, my lord. 1st January 2022.
The
22. 22, my lord. 22, my lord. 1st January
the
2022.
petitioner has been superannuated from service.
My lord, 31st January 2022, my lord. Sorry.
With effect from January 31, 2022. Full stop. The petitioner was initially engaged as a casual laborer, as a group -D staff. Full stop.
Thereafter, the petitioner was absorbed as a regular employee to the post of peon on and from July 23, 2008. With the West Bengal Backward Classes Development and Finance Corporation, within bracket, WBBC, D, and FC. Full stop. The petitioner's grievance is that he was not paid any pensionary benefit or GPF dues between July 2008 and January 2018. Full stop. The no. Under the West Bengal scheduled castes, scheduled tribes, and other backward classes development and finance corporation, within bracket, WBSC, ST, OBC, D, and FD, bracket closed, Act, 2017. All properties, funds and assets under the control of West Bengal scheduled castes and scheduled tribes development and finance corporation and West Bengal backward classes development and finance corporation shall vest in the corporation itself, full stop. Shall vest in the corporation itself. Under section 33, within bracket 3, bracket closed, C, bracket and method, all officers and persons in employment of the corporations under the repealed acts immediately before the commencement of the 2017 Act would continue in their service, could continue in the service of the corporation as established by the 2017 Act and shall hold his office or service by the same tenure, comma, at the same remuneration, comma, upon the same terms and conditions, with the obligations, comma, rights, privileges as to leave, comma, leave fair concession, comma, welfare scheme, comma, medical benefit scheme, comma, insurance, comma, provident fund, comma, other funds, etc., would be continued to be given to the officer. If the officer or other employee opts not to continue to be the officer or other employee of the corporation within a period of 6 months. Full stop. Next. The appointed date of such act of the 2017 Act was November 15, 2017. Full stop. Next. Mr. Mukherjee, learned AGP submits that since the commencement of 2017 Act, the petitioner will not be eligible for pensionary benefits. Full stop. Next. It is written instructions as handed over in court today on behalf of the corporation is retained with the records. Full stop. Next. A reasoned order passed by Additional Chief Secretary, Finance Department, in compliance with the judgment dated March 31, 2023, passed in MAT 1386 of 2021, is retained with the records. Full stop. The prayer for the petitioner in MAT 1386 of 2021 was refused for switching over from CPF to GPF scheme. Full stop. The reasons for the same were the existence of West Bengal Service Rules, 1971, the West Bengal Scheduled Castes and Scheduled Tribes Development and Finance Corporation Service Rules, 1987, Section 33 within bracket 3 within bracket C of 2017 Act, and the notification of the West Bengal government dated September 9, 2009. Full stop. Next. the respondent corporation is permitted to bring on record the 1987 rules as well as the notification dated September 9, 2009 on the adjourned date of hearing. Full stop. Next. Let the matter come up for further consideration under the same heading motion on December 4, 2023. Full stop. Bolded করে দেবেন আর ওই প্রথমে supplementary affidavit filed on behalf of the petitioner is retained with the records. Full stop. Next.
Deeply.
I cannot understand one thing. How will it apply to him if he has been working from 1998? But if his rights have accrued before 2017, how can you take it away?
But for the legislature thought it fair, is the wisdom of the legislature not to take any responsibility.
But you're saying same service conditions, everything is same.
But not the pension. Pension is a separate scheme. Another. Death term retirement benefit rules, frame number 309. So for state
So
government.
you have taken it away for all the employees.
Yes, no, corporation.
All the employees of the corporation, that benefit has been taken away.
He is the only employee to be absorbed in the corporation. But other were deputed staff.
Then
Another 1976.
Mr. Mukherjee, you file a report because by just oral instructions that she is the only employee, how will this court, if she is already eligible?
Makes a provision for payment of.
But you are saying all service conditions that is applicable to her previously. And the problem is that the service conditions also, it's pretty unclear what her service conditions are. And there are audit reports asking the managing director to explain what her service conditions are, why amount has not been deducted. Managing director does not respond. There are two reports. If you look at the supplementary affidavit, there are two inquiries made by the auditors from the managing director with regard to why the amount has not been deducted. There is no response by the managing director. I do not understand how the corporation is conducting itself.
But the 1952 Act ordered if an employee more than 20 employees is there, then will be deducted from under that. When it is.
Yes, it has to be explained. What they have done today in the written instruction, they have given the additional Joint Secretary Finance Department's reasoned order pursuant to the order passed by the Honorable Division Bench. Is that sufficient? Is that sufficient?
Any provisions for payment of scheme or any pension scheme has been framed by the corporation. But it is to be approved by the government.
Very good. But so many inquiries are made. Audit reports cannot be concluded. So many inquiries are made to the managing director. There are irregularities in the appointment. The service conditions are not fixed. How is the corporation conducting itself? The previous corporation.
No, my lord, kindly consider, my lord, the corporation itself is in favor of granting all this relief to the employees. They have written their letter addressed to the finance department on number of occasions. So far the Honorable Division Bench matter is concerned, the
That's the only thing you have handed over today in court.
The stand-up corporation was there to grant them all this relief. But the finance department is not in the mood, my lord, to grant all these things. Once again rejected. That being the situation. But the letter upon which my learned friend is relied upon.
But the Division Bench's order is very clear that you cannot rely on a non-existent memo for denying their claim.
Lordship. For that, my lord, these particular orders of finance department is required to be challenged. Possibly they are going to challenge it. That being the situation. But the scheme is not there. If the scheme is not there, it is rather difficult for the corporation authority unless this court.
You have not answered to all the queries made by the auditors. Look at read the.
I have seen supplementary
affidavit, all the annexures. How do you explain the conduct?
Whether replied or not,
But that liberty is already with us to reply the supplementary affidavit.
No. How will you do now? It is all these queries were made to the managing director in 2013,
Whether
2017.
my lord replied or not, that file is lying with them or not, my lord, I may be allowed to inquire and come back with a reply of this supplementary.
All right, come back.
But the only difficulty, scheme is not there. This is the only difficulty. Deeply up.
This is that matter where, my lord, the punishment has been reduced, considering the court's interim order and the plight of the petitioner, my lord. My lord, lordship wanted to see the rules on the last occasion.
Now, who is on your other side? Devjani.
Devjani Ghoshal, as it appears from
Mr. Bhattacharya, an accommodation was prayed for. Today, no one is coming. I wanted to see the CCS rules. ছিল মানে রুদ্রজ্যোতি ভট্টাচার্য। এই রুলটা একবার দেখে নি। সিসিএস পেনশন রুলসটা আগেরটার মধ্যে দিয়েছিল, ওইটা বার করো। আমরা তাহলে সিসিএস পেনশন রুলটা এখানে বার করে রেখে দিলেই হয়, তাহলে আর একটা সিসিএস পেনশন রুলস। Now the issue is whether the period will be treated as diasnon or not.
That has been covered under clause B, my lord. The period of overstay only with effect from
That is regularized or treated as diasnon.
With effect from the 13 March to 26th April is treated as diasnon.
That is the issue.
Is hereby condoned.
So they have regularized that.
Yes. Yes, madam.
Where is that order?
Oh,
So now what do you want?
my lord, they can disburse the arrears within a time frame, my lord, and the matter can be disposed of, my lord, with a direction upon them to pay the arrears, my lord, and the monthly pension will be, the petitioner will be entitled month by month the arrear amount. Pensionary benefit and gratuity, both has been granted.
You have been given full pensionary benefits and gratuity.
My lord.
And the period of overstay also has been treated as, diasnon has been treated to be regularized.
Yes, ma'am.
That they have to come.
Kindly
Is Mr. Bhattacharya in court today?
But I have not
I
seen.
could have disposed it of here and now. Ashwin, again, I'll have to keep it in December and unnecessary.
Kindly keeps it before the weekend any day, my lord. I'm giving a notice, my lord. This can be.
Ashwin. The order dated July 25, 2023 issued by the Deputy Inspector General, CRPF, as handed over in court today by Mr. Chatterjee, appearing on behalf of the petitioner, is retained with the records. Full stop.
Mr. Bhattacharya, learned counsel appearing on behalf of the Union of India, is not present in court today. Full stop. He was also not represented on September 12, 2023. Full stop. Next. Let the matter appear for further consideration under the same heading motion bolded on January 16, 2023.
Any shorter date, man. This may be disposable. I'm giving a notice to them, man.
January, October 12, 2023. October 12, 2023. Bold. Server copy. Yes.
70, I am the petition led by Mr. Pari. I am praying for adjournment for 10
the
days
respond
to
of
file a
5-6.
affidavit in reply.
Petitioner is praying for 10 days to file exception. Very good.
Already granted.
Again, they want extension. All right, good for you.
It's not good for me. It's a
No.
long matter.
Ashwin. Time to file exception to the report is extended till December 8, 2023, full stop. Let the matter appear for further consideration. The next structure under the same heading motion bold on December 11, 2023. Bold. Full stop, server copy.
Get
72, I am here on behalf of the petitioner. The advocate on record is out of town, praying for not this week.
11th of December.
Well, 72.
They have taken adjournment, Mr. Kole.
Adjournment.
I am paying some accommodation, my lord, for extension of time to file my exception, my lord. Supplementary exception. supplementary report filed by
71
the
and
Union of
71 did a time to file exception or
My lord, list on
11th of December.
11th of December. Evening.
আরে এখানে তো আর কবে আর রিটার্নেবল নভেম্বরে রেখে তো ডেট নেই নভেম্বরে সেম
I'm applying for 76.
Petitioner,
Please respondent, madam.
11 December.
No, this is the additional report.
Same.
I'm going to respond.
Same.
Your Lordship, I appear on behalf of the private respondent in this matter.
11 December.
11th December.
79. 79.
Petitioner. Petitioner, 79. All right, please come. Please come.
Mr. I'm late by Mr. Shubhajay Chatterjee.
Will you submit or not submit?
Not today, my lord.
Now 11th of December. Now I cannot accommodate you anymore. 11th of
Passover, my lord.
No, I cannot accommodate you anymore. November, there I can't give you any date. 80 রাখুন।
Private to bear on that. Right.
11th.
81, my lord, same prayer as like at 73. My lord can tag 81 with 73 because the same issue and same fact and same reason order is involved here.
It will all appear on that date. Just remind me on that date.
As your lordship pleases.
70, same order as in?
73. 73 and 81.
I beg to appear.
What are the 11th? 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 Same.
84 মানে টাইম পাতে পিটিশন আমার
All right. 84 তাহলে দাও, ফাইল দাও।
বাস এবারে রিলিজ করে দাও। Yes.
That matter, Lordship can remember that High
You're
Court.
there?
No, Siddhartha,
You gave
Siddhartha.
record that both the parties are present.
85 is fine.
Siddhartha Banerjee is appearing for the High Court administration, my lord. That matter regarding, my lord, short follow-up 1 March.
Yes, but nothing can be done.
No, my lord, only one thing, my lord.
Nothing can be done. He came on the last time, you were not there.
Yes, my lord, I was
On
not there.
September 18, he
Yes, my
came
lord.
and the other examiner also gave
Both
the
the-
said report.
Both the, my lord, only one thing, my lord, both the examiners are within the panel of the High Court
I cannot.
administration.
My lord, for the
My lord, if
I
your
have
lordship,
even shown
any
enough
in-
indulgence, I cannot.
any independent
My
person,
lord,
my lord,
for
if your lordship, my
my
lord,
lord,
what
for
not,
the High Court administration, my lord, I'm praying for not today, my lord. Kindly permit it today, my lord.
Because he appeared on that date and
my lord,
he,
my lord, I know, my lord, I know, my lord.
all right, not today, come back.
Very well.
Because
Much
he said,
obliged, my lord.
"Your client." No, nothing more I can do. I have tried enough.
And
We
that-
all have tried
that's I
enough.
have seen, my lord. Thank you, sir. We're extremely grateful for the same, my lord.
Item 140, my lord. My lord, kindly.
My lord, I beg to mention, my lord, my item number 89, file is there, my lord, file is misplaced. This
What
is the
will I
position
do?
of item.
File is there, file is misplaced.
Law.
Someone might have taken it away by mistake. You see, someone's clerk might have taken. Sometimes our books
my
were
lord,
also
how can
taken
I
away.
argue, my lord?
No one wants you to argue before puja vacation. Everyone wants you to take it easy. But then sometimes the clerks misplace it. Sometimes our books have also been taken away. We
Well,
used to keep it on the table and it has been
Well,
taken away.
item 140, there was a direction, my lord. Matter will appear on 3rd.